Good afternoon. Hello, everyone. Hello. And welcome to the House Judiciary Committee. Today is March 31, and we will be hearing our Senate cross files or brand new Senate bills today. Our first bill we're going to start with is from the one and only chair of the Judicial Proceedings Committee across the way, Senator Will Smith.
Right.
And if you would be so kind to start with Senate Bill 323, if that's okay with you.
Excellent.
Great. Thank you. And welcome back.
All right. Well, hey, thank you very much. Good afternoon, Madam Chair, Madam Vice Chair, members of the distinguished House Judiciary Committee, my old committee. It's a pleasure to be here with you. Again, Senator Smith, for the record, here to present Senate Bill 323, which is a bill that you are most familiar with as, Madam Chair, you are the cross-file for this bill. So I'm going to just provide a little bit of context. I know I have 3 minutes. Provide context, walk through the bill very quickly, tell you some of the changes that we made over in the Judicial Proceedings Committee, and then stand by for questions. Obviously, this committee is very familiar with the Juvenile Delinquency and Prevention Act, the JJDPA, which requires sight and sound separation for those youth placed in the adult system or in adult facilities. Maryland is an extreme outlier in this regard, so much so that the Maryland data are not incorporated into the national picture because we tilt the scale so much. So we have more infractions than any other state in the union, over 1,600 last year. That brings us out of compliance with the JJDPA, costing us money, but also doing harm to the youths that are exposed to adults when they are in adult facilities. That, in conjunction with the fact that in Maryland, we have 33 offenses that can be auto-charged when the youths can be automatically charged as adults. We charge more youths as adults than any other state per capita, except for Alabama. 9 out of 10 of those youths charged adults are children of color. 8 out of 10 are black children. It costs us tens of millions of dollars every year when a youth starts off in the adult system, and we know that ultimately 80% will come back down to the juvenile system or have their cases dismissed. And you're getting worse public safety outcomes. So if you are not moved by the technocratic piece of this, meaning cost savings and better public safety outcomes, maybe you'll be moved by the fact that this bill will help address some of the significant racial disparities that exist within our criminal justice system, especially with the juvenile justice system. So the bill before you curtails the practice of what can be automatically charged, of the offenses that will be automatically charged, that youths can automatically be charged as adults. Obviously, the judge still has the ultimate decision-making power. There will be an adversarial process where a prosecutor and the youth's attorney will be present, and a judge will make that decision. You still have the waiver and transfer process at play. And so there are lots of safeguards to ensure that each case is dealt with on an individualized basis, and the best outcome for the youth, and more importantly for public safety, is offered up and actually is carried through. So with that, Madam Chair, the offenses that came in, the 3 offenses that, or the 3 categories of offenses that we stripped out in the Judicial Proceedings Committee. One was for lack of a better term, sawed-off shotguns, possession of sawed-off shotguns. And then the second piece that we changed is that automatic charging is retained for children 14 and 15 for first-degree murder and attempt, and first-degree rape and attempt. With that, Madam Chair, I see my time has expired. I'll conclude and ask for a favorable report and stand by for questions.
Thank you, Mr. Chair. Delegate Arakan.
Thank you so much. Welcome back to the Judiciary, Mr. Chair. So you said you kept first-degree murder and attempted first-degree murder and first-degree rape and attempted rape. Is that what you kept in there?
For 14 and 15, that's retained.
Okay, retained for 14 and 15-year-olds.
Position. That's right.
Okay, and then what would that exclude? So what's outside of that? So what are we looking at? So
the bill retains, which means that automatic charging is now not a thing for the following offenses: possession, sale, or transfer of regulated firearms, use of a firearm during a drug crime, use of a firearm with a felony drug conviction, first-degree assault, wearing, carrying, or transporting a handgun.
Okay. All right. Thank you very much.
Thank you.
Thank you. Members, do we have any other questions? The Vice Chair.
I'm totally surprised that there are no other questions.
So am I, actually, Madam. But I was delighted until.
Are you opposed to this body strengthening the bill and sending it back?
So I'll say this. I would caution against changes being made, just given the tenuous nature of the coalition that we had to cobble together to get this bill over here in this form and fashion. So if you were to change it, look, I think this reform is long overdue, and so I would say I would like to see all auto charging curtailed, all 33 offenses curtailed, because then you'd have a judge and a prosecutor and the attorney making, in an adversarial process, making an informed decision as to what's the best for public safety and for the child. That being said, this is at this late hour, and I'm pulling this list up because I put this list together. Not only did we obviously have a very fragile coalition to get this bill through, but listen to what is before, and this is what is going to be on your docket if you choose to address it on the floor in the House of Delegates. And this is what's come over from the Senate. It's the PACE Act, you got the Voting Rights Act, clean slate shielding, social media location, Glock switch ban, anti-masking, auto charging, trans birth certificate, HBCU program duplication, non-tenured faculty collective bargaining, local hiring ethics bill, pre-release center, 2 of the 3 major housing bills from the governor's office, economic development bills, and then state-level NLRB. That's a lot of work for the last week and a half of session. If this changes and has to come back and then back, I think you're going to greatly jeopardize the progress that this bill represents, understanding that the offenses that are in the bill right now amass for the lion's share of the youths that are currently charged as adults. 500 kids will be helped through this bill. The offenses that are stripped out, one was the sawed-off shotgun. No kids were arrested for that or charged for that. And then the other offenses, it's 8 or 9 kids. So I understand from a moral purity piece, but from a practical application in this setting and our ability to get something like this done after 14, 15 years of trying, I would caution heavily against jeopardizing the prospect of that progress. But Madam Vice Chair, the bill is in your possession and defer to your sound and wise judgment on that.
So if you ask, we will ask, and therefore, Delegate Cardin.
Madam Chair, just real quick, thank you, Senator. With the changes, some would say that this is, I guess our Vice Chair would say this isn't as strong as the bill that we worked on. Given that and the changes that you made, the State's Attorney's Office, I'm assuming, is still adamantly opposed to your legislation. Is that true, not true? And the advocates who were trying to work with us on the other legislation, are they now unhappy or are they going to be satisfied? Just curious to know what your feeling is on that so we know what to expect.
Well, I would hazard to speak for either of those kind of coalitions, but look, the state's attorneys have come out in opposition. I will tell you that there's internal conversation within the State's Attorneys Association as to what position to take on the bill, but publicly they've been very public in their opposition. For the coalition that is in favor of this piece of legislation, they would like to see the strongest bill possible pass, and I understand that. We are in the legislature. I've spoken to kind of the logistical complications, but a compromise here is not a bad word. This is significant progress, 15 years in the making. I would just hate to see us drop this ball.
And I'm hearing your words very clearly, so it makes sense. I just wanted to figure out what I'm going to hear after this hearing. That's all.
Thank you very much, Delegate. And like I said, I'm in no position to dictate anything. This is your bill.
Thank you.
Your choice.
Thank you. Delegate Phillips.
Thank you, Madam Chair, and thank you, Mr. Chair. I appreciate all of the hard work that you've done in pulling together the coalition. I appreciate my chair, because I know she's been communicating with you the whole way through. And I've had an opportunity to be up close and personal on these issues for the last 18 months working on the Juvenile Justice Reform Task Force. I'm going to ask you a couple of questions. I'm a numbers guy, right? With the bill that way that it's crafted today, would you say we get about 60% of the youth on an annual basis that are charged in this way?
That's according to the data that I have, that's correct.
So 60% of the youth. Does this give the Department of Juvenile Services an opportunity, because we know that there's a lot of concern about their capacity to prove out the point that they can manage at least this piece before we move on potentially?
That's right, Delegate. I mean, it's going to help 60%, obviously, we know. It's going to provide us an opportunity to have proof of concept once it goes. It's going to bring us into compliance with the JJDPA. But I neglected to mention that the vice chair, another bill of the vice chair's bill to ensure that there is sight and sound separation within those facilities, that's mended into this bill. That was Senator Love's bill on the Senate side. So that, although the 60% are going to be helped in terms of the curtailment of the auto charging, all of the children in this juvenile justice system will be helped by the bill as offered before you, because it's going to bring us into compliance with the JJDPA, which is the strong work of the chair and Senator Love.
Now, I'm going to ask you a little bit of a tougher question, Madam Chair, if I can. There are two charges where there were a lot of young people that get caught up with these two charges. Yep. One is armed robbery, and the other one is armed carjacking. Right, and I'm looking at DJS statistics, which suggest that those are like two major categories that by the time you're done in calendar year 2025, there were 147 youth charged in adult court. At the end of the day, there were 9 that were actually kind of found guilty and actually incarcerated. That's a big drop, right? So I hope that we look at something like that when we come back. And then with armed carjacking, there were 62 that were charged in adult court and 5 that actually served more than 18 months in prison. So as we consider this, I'm not suggesting anything for right now, Mr. Chair, but I think we got to come back and look at some of these places where we've got youth charged as adults, but they end up back in our juvenile system, or if they are adjudicated as adults, it's very few of them.
No, message received, Delegate, and it's my full expectation that once this bill goes into effect and there's a proof of concept, we know that you're going to have better public safety outcomes, better outcomes for the youth, that it will not matter what the charge is. We'll understand as a state and as policymakers that this is the right place to move into. So I think this is going to help make that case for further reform, and it's my full expectation that we'll continue that conversation.
Well, thank you, because I'm tired of being compared to Alabama when it comes to right.
Hey, you and me both, but you said it first.
Delegate Valentine.
Thank you, Madam Chair, and thank you, Mr. Chair, for being here. I only had one question about the offenses that were taken out and what the logic was with your committee, the first-degree assault. Could you just kind of go over what the thought process was, why that one was taken out?
So thank you very much for the question. The first-degree assault is still retained in the bill, so that's meaning it's not auto charged. But for the first-degree murder and attempt and first-degree rape and attempt for children 14 and 15, that was removed, and that was just a subject of a lot of debate within the senators that were supporting the bill. And when it came down to it, a lot of senators felt like they just couldn't support those offenses being included. And so admittedly, that was a concession I made to ensure that we had a strong coalition moving forward to make a strong statement for support of the bill. And that was to address some of the concerns and assuage some of the concerns that some of the senators had.
Thank you, Madam Chair. Thank you.
Thank you. Delegate Mangione.
Thank you, Madam Chair. Thank you, Senator. Just kind of to piggyback on that, just so I make sure I understand correctly. So in the bill, if you are charged with multiple crimes like a first-degree assault and you have a gun on you illegally, do you still automatically start in juvenile? Or?
No, if you have an offense that is chargeable as an adult, you're going to go up to the adult system first. You're going to start there, and then you'll have a transfer hearing. I mean, there'll be a hearing to decide where you go, but you're going to start off in the adult system under those circumstances. Okay.
And then what about, how does it differentiate somebody that is maybe a repeat offender? And thank you for...
No. So it's charge specific, but that information will be brought before the judge to make an informed decision as to whether that child should start at the adult system or whether they should originate in the juvenile system. So in that sense, it doesn't impact it. One other thing that the bill does is that it does have mandatory holds. So for instance, there was a lot of talk about people getting picked up for gun crimes, for instance. And now DJS, it's their policy. This just codifies their policy. They're doing this today. But they have to be held before they can go before a judge. And that, I think, balances public safety and the interest of the child to understand where best they should start, but also public safety, ensuring that if someone's involved in some serious criminal activity, that we have an opportunity to take a deep dive and understand what's going on there.
Thanks for your interest.
Great. Seeing no further questions. Oh, Delegate Taylor.
Thank you, Madam Chair. Thank you for being here. Appreciate this. And I think, to me, you know, we ought to send the strongest message to our community. So I would advocate that all the charges would be included. But let me ask you a question. It's procedural. And you've said that if we were to send this bill back, right, that potentially the real problem would be when it comes back here, we'd be too busy to deal with it. Just wondering, in your committee, do you think we get it out, though, if we were to send it back?
So I think there are two, thank you very much for the question, and good to see you. So one is that it will, if it has to come back over to the Senate and then it comes back over here, if we amend it in other force, I've talked about the logistical concerns there, but it's going to be a difficult conversation to have in the Senate. It's going to gum up time on the Senate floor. Again, a considerable amount of time. And so we're going to relitigate with these new offenses, and that's where that's going to happen. And so I think there are complications on both sides. Could we get it out of the Judicial Proceedings Committee? Open question. I haven't put that before the committee. It came out this way for a reason, and so you know, it's an open question. I don't know the answer to the question.
I appreciate you trying.
Thanks.
Thank you.
Thank you, Mr. Chair. And how many times have you put the auto charging bill in?
This is I think, second time doing it, but this has been before the General Assembly for at least 14 years.
And what was the vote?
On the prior iterations of this?
Yes.
On my bill, we did not have a vote on it.
Right.
And in prior years, I don't think that we've been able to have a successful vote.
In either committee?
In either chamber.
Right. And so this would be, so your chamber was able to get out a bill, and this is the bill we have before us for the first time in 14 years?
That's correct,
Or maybe
Madam Chair.
15 years. Okay. Thank you very much. Any other questions? Thank you. Seeing none, let's go to our next bill. We have a schedule, we will deviate from the schedule, and the reason for that is when I see a senator, I call a senator. So just keep that in mind, because they've got other work that they need to do across the way. Chair Smith, whenever you're ready.
Sure. Thank you very much, Madam Chair, Madam Vice Chair, members of the distinguished House Judiciary Committee. Senator Smith, for the record, here to present Senate Bill 822, which I believe is the cross-file with Delegate Embry. You've seen this bill before. It seeks to implement some long overdue technical and then substantive changes in our parole system. Majority of the 15,000 or so people currently eligible for parole will never meet with a parole, or never meet with the Parole Commission. I believe, Madam Chair, that this is the first time in a very, very long time that the Parole Commission, comprised of 10 people, is actually at its full complement. It's been a long time. I do want to give hats off to this administration. This isn't a partisan comment, but this administration has been particularly good in making sure that the commission is fully staffed up at 10. This has been a problem in both Democratic and Republican administrations, so I'm not making a partisan statement there, but I do want to commend their leadership and their ability to fill these critical spaces on the commission. So approximately 6,000 currently eligible people will have their hearing decided by a commissioner. The lion's share of the work, however, is done by the hearing examiners. And I know you've had robust debate in this committee about the qualifications for examiners and how they're selected, and we'll talk a little bit about that in the next bill. But the remaining 9,000 of those folks, as I mentioned, will hear a commissioner. So the commissioners are really the workhorse for the process. And this bill makes a number of changes to the parole process to create a fair process by allowing more transparency in how the system is functioning. And it also brings our system into alignment to the policies that are employed by the vast majority of other states. Not that that's dispositive, but it just gives you some context for what we're attempting to do through this bill. So very simply, the bill establishes a date certain for when incarcerated individuals will have a rehearing before their next parole, because that's the first part of it. So if you have, it's 2 years or later for a sentence that's 10 years or less. It's 3 years later for a sentence if you're sentenced to a crime with 10 to 20 years, and then it's 3 to 5 years later for an offense greater than 20 years, a sentence greater than incarcerable for more than 20 years. 38 states have this automatic scheduling process that we're proposing here. 7 have annual reviews for parole, and 13 have annual parole hearings for some but not all parole eligible individuals, and I have that information as well. The bill also requires a number of technical changes, but very important for the incarcerated individual to understand the reasons why they may have been denied parole and some of the positive steps they can take while incarcerated to increase their chances, or understand that it's probably not going to happen. So just to have a more informed process. The bill requires these hearings to be recorded and those recordings to be retained for 3 years. It requires that the parole commissioners consider the original victim impact statement in addition to the updated impact statement. So we worked very hard with the Victims' Rights Coalition and advocacy groups to ensure that the voices of the victims were heard and never forgotten. The bill requires that the reasoning and the justifications for a vote to approve or deny parole be made available to the public. And it decreases from 21 to 14 days the time in which the report recommending parole denial or parole to be completed, and requires that such report include the reasoning and justification for that. 27 other states do this, and 12 make those decisions public. There's also an annual reporting requirement, and with that, Madam Chair, I can go into the details of that, but I see my time's expired. And with that, I'll just ask for a favorable committee report and stand by for questions.
Members, do we have any questions? Seeing none, please proceed to your next bill. Thank you.
Okay. Good afternoon again, Madam Chair, Madam Vice Chair, members of the House Judiciary Committee. Senator Smith here to present Senate Bill 823, which is the cross-file for Delegate Phillips' bill, or somewhat of a cross-file, not exactly a cross-file, but we're in the same neighborhood. The Maryland, we talked about the structure of the Maryland Parole Commission statute. It says 10 commissioners. I think we're at our full complement just this session, but the examiners do the lion's share of the work. The majority of the way that the commissioners are selected is that it's chosen by the Secretary of Public Safety and Correctional Services with little transparency into that process. So what this bill seeks to do is implement a process. It makes 2 changes to the process of appointing members. So it creates a commission that will select candidates for consideration by the governor, subject to the approval by the Senate Executive Nominations Committee. And the bill spells out the members of the commission that are enumerated in the bill. I won't go through all of them. We did make one change in the Senate. We removed the school superintendent position. And so we can get a little bit more to that rationale during the Q&A. But this bill, to my research, most states give the governor the appointment power for the commissioners and then subsequent to some sort of legislative oversight. I think there are only one other state, Kansas, that the secretary still makes these appointments. And the problem is that a lot of the folks are coming up through the department and selected by one person with very little oversight from us. And so to make this process more transparent and accountable to the public, I'm offering these changes through this bill. And with that, Madam Chair, I will ask for a favorable report and stand by for questions.
Thank you. Members, do we have any questions? Delegate Phillips.
Thank you, Madam Chair. Mr. Chair, I know we didn't quite sync up the legislation that I have and the legislation you have. Both of them include the commission to make the selection of potential candidates for parole commissioners. In that, one of the things that we did was to talk to a number of advocates and people in the community. And I think in ours, we added a formerly incarcerated person and a family member that have been impacted by the correctional system. Would you be open to something like that?
I think we tried to balance it with, obviously, with a victim's rights person and then, someone in.
And a victim's rights person, just
Exactly.
so you know.
So we did that. I think having someone, a family member of an incarcerated person, maybe an inch too far, but I'd be willing to entertain on the Senate side. I think that's a good idea to think about having someone that's formerly incarcerated. We did have an interesting. We've tried to balance the interest here. And without having a formerly incarcerated person on board. And I think we've done that, but it's a good conversation to have, and I'm not adverse to it. But I think having a family member in conjunction with a formerly incarcerated person, maybe just a hair too far, but, or just not needed for the balance, but open to the conversation.
Okay. And is there, both my chair and my chair, because ours are not in sync, and I'll be talking to JPR soon enough.
Yeah.
Is there a way of just trying to figure out how we, not necessarily merge, but we kind of bring the best of both worlds together?
I think so. I mean, I think you, and I'm not remembering all of what you did in your bill, Delegate, but I thought you had some really elegant things that were involved, especially for some of the hearing examiners. I think you worked very diligently with the unions and folks that were initially worried with it. So I think some of the suggestions that have come down there for qualifications and so that selection process are actually pretty elegant, and would be interested in incorporating those into this bill. And if you saw fit to amend it that way, I think that would be great.
Okay, thank you, Mr. Chair.
Great. I'm going to go to Delegate Woods, and then I'll go to you, Delegate McCollum.
Thank you, Madam Chair. Thank you, Mr. Chair. Just out of curiosity, can you tell me why the school superintendent was removed?
So it's interesting. We had a conversation. One member, brought up something that I think resonated with the members of the committee, that it wasn't directly related to post-secondary education, because a lot of the good work that this committee's done and my committee's done is we've been able to build opportunities to earn diminution credits, for instance, to get certificates and to get even college degrees, associate's degrees and such. So that's all post-secondary. And so maybe less relevant, but if an equivalent to someone that deals with community college or collegiate level stuff or our vocational training, that might be more appropriate because it's more applicable to the actual experiences that incarcerated individuals are having and some of the opportunities that they have while incarcerated. But GED things are also happening, and obviously education is being provided. So it was that it wasn't directly on point, but I could argue both sides of that coin.
All right. Thank you. Thank you, Madam Chair.
Thank you. Delegate McComas.
Thank you, Madam Chair. Senator, have you considered having, and I was trying to see if you actually had it in there, victims of crime, either, victims that have lost family members to murder or sexual assault, or, people that have actually been harmed, and basically, because I think that's another piece of the whole thing. And then also somebody that is experienced in dealing with folks that have substance abuse problems, because I mean, they're in jail, so they're hopefully not getting drugs or alcohol. But the point is, you want to make sure that people are, that they can handle getting out and they're being on parole or probation and not re-offend. And I think that's a serious issue.
No, Delegate McComas, I think I hear you, and that dovetails with what Delegate Phillips was saying. When you have an incarcerated individual, then also an actual victim, so then you kind of build and build and build. Whereas what we've done is to create that parity by having a victim's rights advocate and a prisoner's rights advocate. And I thought that met the balance. And so having a formerly incarcerated individual or an actual victim may be superfluous, but I again defer to the wisdom of the committee and as it relates to the substance abuse. We did add in 3 service providers in the fields of mental health, substance use and treatment, vocational educational training, community organizing, all appointed by the governor. So we think that those interests are met through those appointments.
Okay, great. Members, any other questions?
We're going to vote on your bill, by the way, JB.
Seeing none. All right, seeing none. Chair Smith, you want to go to your next bill? Would it be Senate Bill 514?
Yes, yes,
Okay.
ma'am.
Senate Bill 514.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. Senator Smith here represents Senate Bill 514, which is, I believe you all have the cross file here for third-degree assault. The history here is interesting, and some folks may remember this, and maybe one member of council or their significant other may remember this. Back in 1995 was the first attempt to move assault from a common law definition into statute, and the initial group met over summer, and they came up with 4 degrees of assault, then came back a year later and ultimately landed on first and second degree assault, which is what we have today. And clear understanding of first degree assault, very serious, a felony, up to 25 years of incarceration. For second degree assault, however, there's just a wide berth of activity that falls into second degree assault, everything to something that's more significant to a simple push. And for folks on both sides of the aisle, and there are significant consequences for a conviction of second-degree assault, especially if it carries, I believe, in a period of incarceration for more than 2 years, which means there are significant consequences for even gun ownership and lots of other collateral consequences for a conviction for a simple push or a shove in a bar. And so the initial bill for third-degree assault actually was offered in this committee by the then chair and vice chair, Delegate Joe Valerio and Delegate Kathleen Dumais in 2018. Offered this bill that we have before us, and it didn't go anywhere. But we've had a long time to kind of to talk about this and to study this, and so this creates a third degree assault, which is a misdemeanor. It's a citation up to 90 days. The bill is a lesser and included offense to second degree assault, but it offers, I think, defendants and state's attorneys just options to have more just outcomes for conduct that just doesn't reach to the level of second-degree assault. So with that, Madam Chair, members of the committee, I'd ask for a favorable committee report and stand by for questions.
Thank you. Do we have any questions? So, Mr. Chair, I just want to confirm, this is still in the same, this is in the same posture as we sent it over? No, okay. I see an amendment in the file, but it's the judiciary amendment, so I wasn't sure.
Okay, we amended, so we did amend it, and I know you all have sent a commissioner's bill over. I think it's being heard today. Yes. in the Senate, in the Judicial Proceedings Committee. We said that you couldn't charge by commission. So and we kind of cabined that you couldn't have a commissioner do this because we kind of see where things are going. We're trying to balance interests. I know that there's a more global conversation, but we did tack that on. That's on the interlineated copy. So we did amend it in that fashion. And then I think we added some language to make sure that it was clear that third degree was a lesser and included of second degree. Which is, I think, maybe obvious, but we put
just to make it clear.
Yeah,
sure.
yeah.
Clarification is never a bad thing. Any other questions, members? All right, seeing none. So now we're going to move to what I believe is your final bill for the day.
Yes, ma'am.
It's been a pleasure having you over here. This is Senate Bill, well, which one is it?
512.
Okay, Senate Bill 512. And do you have Debbie Feinstein? Oh, yes. There you are. Good to see you all. Debbie Feinstein and Lisa Jordan for Senate Bill 512. Chair, whenever you're ready, you may begin.
All right, thank you very much, Madam Chair, Madam Vice Chair, members of the committee. Senator Smith here to present Senate Bill 512, which changes, the crime of stalking to a felony. We've had a lot of conversation. I know that there is consternation amongst this committee and also in my committee with enhancing penalties, but we believe that this is the right policy choice under these circumstances because stalking is a significant crime that has not been adequately dealt with. And you'll hear from our state's attorneys and Ms. Jordan from MCASA to give you some vignettes and examples of why there are some lapses in the current law and why I've got the bill here before you today. Conviction for stalking is a misdemeanor. It's up to 5 years of incarceration or a penalty of $5,000. But there's no enhanced penalty for repeated stalking, and that's where you're going to hear some of these stories where we're running into a lot of trouble. Stalking has also a high correlation to homicide. 76% of female homicide victims have been stalked by the person who killed them. Their intimate partner has physically abused 67% of a female homicide victim. 89% of female victims who were physically assaulted were also stalked in the 12 months before their murder. And 79% of abused female homicide victims reported being stalked in the same period that they were abused. So as I mentioned, Madam Chair, this makes this a felony if the person who committed the act had either of the following. So they had an interim temporary protective or final protective order in effect against the person at the time of the offense in which the victim was a petitioner, or the person had a court order in effect against the person at the time of the offense prohibiting the stalking of the victim. They had previously been convicted of stalking. They had previously been convicted of stalking of a law of another state or jurisdiction. That's something that we wanted to close that loophole as well. And so with that, Madam Chair, I'm going to defer to my witnesses to give you some real-life practical examples as to why this bill is necessary. And I'll ask for a favorable report.
Great, thank you. Ms. Feinstein, do you want to begin?
Thank you.
We just need a microphone if you,
Yes, I do.
one or the other.
Thank you so much. Good afternoon, members of the Judiciary Committee, Madam Chair. My name is Debbie Feinstein. I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. I'm also co-chair of the Maryland State's Attorneys Association Special Victims Subcommittee, which is a compilation of all of my colleagues doing special victims work around the state. I have a number of examples, and I also want to mention that this bill is somewhat limited from a bill that this body has seen before. We had proposed a bill several years ago that elevated all stalking cases to felonies, but we've now narrowed it down looking at the data. And we've narrowed it down to specific cases where the offender is essentially on notice. They've either had a prior conviction for stalking or they're on notice from the court to stay away from this person, either because they're on probation or because there's a pretrial condition or because there's a protective order, and yet they still can't stay away. A specific example in Montgomery County came where a defendant and a victim were estranged spouses with 2 children in common. When they separated, the victim stayed in the family home with the 2 children. He tried to stalk her by waiting at her job, circling her in the parking lot, and placing a tracker on her vehicle. Using that tracker, he followed the victim to the commissioner's office and even approached her there to stop her from filing a protective order against him. He broke into her home 2 times while the protective order was active, placed a nanny camera in her bedroom wall socket and watched the victim, sent various items through his Amazon account to her home address. Even once he had been arrested and was pending trial for stalking, he would say he was not going to stop, and the victim was his wife and she belonged to him forever. This was even while he was pending trial. So he was in violation of the protective order. He was charged with stalking, and yet he faced 5 years, a 5-year misdemeanor, which is not a crime of violence. Essentially, he would serve about a year, a little over a year plus for that offense. And what we're talking about, and contrary to what the public defender had presented in their testimony, they talked about this isn't a good thing for deterrence. And I would indicate to this body that this is an important thing for punishment and for community safety and for safety of the victim. I have many more examples that I can tell you where the penalties have not been sufficient, where we have repeat stalkers. Because even if you're convicted twice for stalking, you still are going to have 2.5 years to work with total on 2 5-year misdemeanors. And it's just not adequate. I would urge a favorable report, and thank you for the indulgence of the committee to speak a couple more moments.
Thank you very much. And members, I'm going to run over to the Senate, so I just wanted to let witnesses know this is no indication of your testimony.
Thank you, Vice Chair.
The Vice Chair will preside.
Thank you, Chair. Yeah.
All right, Ms. Jordan, have you testified already?
Not yet, Madam Vice Chair, if I may.
Proceed.
Good afternoon, Madam Vice Chair. Madam Chair, as you leave the room, members of the committee, I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're also here in support of Senate Bill 512. I don't want to repeat what has already been said, but stalkers are both persistent and dangerous, and I want to be sure that the committee understands that in these cases where you have someone who already knows they're not supposed to be stalking, who already knows they're supposed to stay away from someone, this bill really will help prevent not only the stalking, but also other violence, and specifically sexual assault. Nearly half of victims stalked by an acquaintance are then sexually assaulted by the stalker. Nearly half. 48% of sexual assault survivors between the ages of 18 and 24 also experienced stalking. And 1 in 10 stalkers who had no prior relationship at all, so not intimate partner violence cases, not dating cases, no prior relationship, if they make a threat, they will act on it. And we're talking a lot about the stalkers, but just for a moment, imagine you are one of these victims. You know, often we tell people, report. We have cases we're talking about with Senate Bill 512 where people have reported, they have ordered, and now it's not stopping. It is continuing. Imagine the fear. Imagine the inability to get protection from this repeated crime. I appreciate all of the reasons this committee hesitates to increase penalties, but this is a situation where we need more penalties to help keep the community safe. So the Maryland Coalition urges a favorable report on Senate Bill 512.
Okay, thank you. Questions? Delegate Conaway.
Thank you, Chair. Thank you, panel and Senator, for coming in to testify. To the last person that testified, did you say that there are stalkers that don't have intimate contact, but there's a high level of death risk? Can you give me those numbers again?
Yeah, it's any sort of threat. So for 1 in 10 stalkers, so that's 10% of stalkers who have no prior relationship with their victim, if they make a threat, they're going to act on it. So if they threaten to beat someone up, they're going to do that. If they threaten to kill someone, they're going to do that. If they threaten to sexually assault someone, they're going to do that. So these are people who, they're strangers to their victims. They don't know each other, but they make a threat, and 10% of those, they're going to go forward on that.
Thank you. To the other witness on the far end, when you gave your example, did you say the 2 people were living together at first?
They were initially living together, and then they were estranged spouses, and they have 2 children in common. So they were married.
Yes.
And then they separated. The victim stayed in the family home with the children, and he moved out. And that's when his course of stalking began. Didn't stop even when she got a protective order. He would break into the house. It was just a persistent. Nothing stopped him, even court order.
So he moved out and then kept stalking.
Correct.
Thank you very much.
All right. Delegate Cardin.
Okay. Thank you, Madam Chair. Thank you very much for the bill. I guess this is for you, Ms. Feinstein. So if you are convicted of stalking, a judge can give you up to 5 years, right?
Correct.
And you're saying that they'll only serve 2.5?
Not even typically. It's not a crime of violence, so they're eligible for parole after a quarter of the time. And yeah. And that's what we're seeing.
So they're eligible, but they're not guaranteed parole?
That's correct.
Okay. How often have you spoken with the judiciary about whether they want to put people behind bars for more than 2.5 years? I mean, I'm just curious. I mean, I'm honestly, I don't know the answer to this. I'm just wondering, like, are they assuming, you know what, this person needs 30 days, so I'm going to give them a year and they'll be out in 60 days or whatever? I mean.
I think that's I don't know. I have not spoken to the judiciary specifically about this bill, but I think the judiciary certainly is aware of what the actual amount of time someone's going to serve. And it's also minus good time. So it's a quarter time minus good time. So it's actually even much less than that. And look, and I understand that's a separate problem.
But are they giving the maximum knowing that they're going to be out in a year?
In the most egregious cases, potentially, yes. I mean, I have another case example where someone was convicted of stalking, then went after victim B, let's say, victim number 2, who had been helping victim number 1, and so then started to go after victim number 2 while on probation for victim number 1 stalking. Victim number 2 got a peace order, and then he continued to stalk her, and he was ultimately convicted of 2 counts of stalking, including the violation of probation, and he was out of jail like before a minute passed.
Well, okay. I understand that, but
yes, sir.
If, in fact, a judge was empathetic to the fact that they had 2 stalking and a VOP, and they wanted to make sure this person was incarcerated for an extended period of time, the judge has the ability to make sure they're not getting out after a minute, or as you said.
Not the judge, that would be the parole commission?
Well, no, if the judge is, he's in front of the judge for the VOP, is he not?
Yes, but I guess what I'm saying is for the violation of probation. So in that case, there was a conviction for stalking, which is a maximum of 5 years. I can't remember exactly what.
But he got 2 convictions for stalking.
Well, right, but the violation of probation is encompassed within that first stalking. He can't exceed the 5 years total for what he had already served. And then
on that one, but then he's got the
right.
second one.
Correct.
Plus he's got the violation of probation, plus he's got the violation of the peace order. So it seemed to me that either a judge or multiple judges, probably multiple judges, knowing this record of this person and having a state's attorney making sure that they know that, they would make sure that this person is not getting out after a year. It would seem to me. And if they're not, then it's not a question of having the ability to, but choosing not to. Would it be?
I hear what you're saying. In that case, the court did max the defendant out on all of it, and he was still out within a couple of years with good time and parole eligibility. Okay. So there's just limits to what is available right now. I hear you that there are, and we do ask for those penalties in the relevant cases, but even when we get them, I would submit to all of you that they're not sufficient. Okay. And I would also note, because I didn't have time before, that we are a complete outlier. We are the only state in the country, there's one other state in the country, one of 2 states in the country that doesn't have an enhanced penalty or makes stalking a felony, and I have a whole study that we did on that. So it's acknowledging the lethality, and it's giving the judiciary tools. I will tell you in that case, that second case example I gave you with A and B, that judge wanted to give much more time to that individual. He was incredibly scary what he was doing, and those victims still don't feel safe.
No, and I appreciate that. I'm just trying to figure out if it's that we're not sentencing them properly or that we don't have the ability to, and that's what I'm trying to figure out. Okay, thank you.
It's the ability. Thank you so much.
Thank you. Delegate Woods.
Thank you. I want to, out of curiosity, get a picture of a person who was previously convicted of stalking, but now uses for an excuse that they're showing up at locations where perhaps they are watching their children perform in activities or something like that.
So in that example, if there's an exception in the probation contract, like a lot of times what'll happen is there'll be no hostile contact or contact being allowed relating to the minor children. It depends. I mean, that's a separate civil proceeding. That's probation conditions, and then there may be a protective order, child welfare could be involved, so there's lots of different layers.
So I'm going to stop you because I don't think you understand.
No,
I'm
maybe
saying
I don't.
Not related specifically to the child, but what if the adult is feeling like this is an intimidation because the other parent is coming so-called to observe their children? In other words, there is no protective order against the child per se. It's because of the stalking adult to adult.
Well, I think under those circumstances, we probably wouldn't have a criminal case if there's no prohibition on the person being.
But what if the adult had a previous stalking charge is what I'm asking.
And if we had, beyond a reasonable doubt, evidence that the parent was only coming to that children's event for the purpose of a malicious course of conduct to cause emotional distress to the other parent, or to maliciously have a course of conduct where they're following them and stalking them, I just don't see under that case, that example, that we would have enough for criminal intent.
Okay.
I will tell you that, and I hear the concern with respect to bleeding over into custody matters and children. We're not in the business of trying to litigate the family law case. We're in the business of trying to keep people safe where it's provable and necessary.
All right, thank you so much. Thank you, Madam Chair.
Thank you. Delegate McComas.
Just briefly, thank you, Madam Chair. From what limited experience I've had with clients or with the other side, the question is, a lot of times it's a mental health issue too. And it's like they just can't untie the knot. And so I guess because you guys are experts, do you think that that's a significant component of this stalking? Because, here there's this threat of going to jail and a tremendous fine, and yet they just don't stop. They just keep doing it.
So I think what we're seeing, thank you for your question. I think what we're seeing is a power and control dynamic. Why does the domestic abuser repeatedly abuse the spouse or the prior girlfriend, even when they've been convicted before? We see it all the time. It's power and control. Will the person report? Will they not report? I agree that there is, or I would say to you, there is 100% components of mental health that intersect with this issue. But on probation, someone can be required to get mental health treatment. And if they can't conform with that and can't conform their behavior, then we need to, again, go back to this issue of how are we protecting the victim, her family, and our community, given the nexus to lethality and the nexus to sexual assault and other dangerous behavior.
My question is so if ultimately it's really, it's a power and control issue, and it's almost like psychotic, okay, that whole thing needs to get resolved, and I don't know how you do it.
Well, I will tell you in Montgomery County, and I guess if Ms. Jordan wants to add anything on this as well, I'll tell you in Montgomery County, if there is that piece, we would refer the individual on probation to participate in an abuser intervention program where that is a specialized type of treatment that has a mental health component. It may have a substance abuse component, prevention, and treatment component, and look at that issue holistically. In Montgomery County, that program is 26 weeks long and takes a deep dive into the issues related to power and control. So when we're looking at this case, let's say there's been a prior. The person's been ordered to do the abuser intervention program. They've been ordered to get mental health treatment. They aren't following through on those things, and they continue to stalk. At some point, the onus has to be back on them squarely and back on the fact that we have to protect the victim and potentially their children and other members of society.
All right, thank you. Delegate Phillips.
Thank you, Madam Chair. On this one, when we start talking about a pattern and previous stalking offenses, it would only apply if they were found guilty of a previous stalking offense?
Yes.
No information could be shared about potential patterns that were not convictions. Is that, and let me tell you why I'm asking this question. I had early in my career, I had a spousal scenario that you described, and it was very clear that one spouse had become somewhat unhinged and began to use alcohol as a crutch, and was clearly stalking my client, and there was a protective order. It got really bad because this individual showed up in my office and began stalking my office, literally. But needless to say, I didn't bring a complaint, but it was a pattern that had been created. I'm just curious about additional testimony that could go into something like this, because often, it may be hard to get to criminal charges for stalking, right? This is kind of deep, but this pattern, these things happen. I'm sorry, I'm just reflecting. I'm kind of thinking back.
So I can tell you how I, as a assistant state's attorney, would handle that situation. Stalking can be charged as a course of conduct. So if the individual, the victim, the survivor of the stalking wants to prosecute or wants to go forward in a criminal case, we would be able to go back and extend over that course of time, because this body has extended the statute of limitations for stalking. So we would potentially be able to charge all that conduct. Even if we weren't, the prior conduct, I would file a motion for the admission of prior bad acts, because I would show that the intent was clear from prior incidents as they relate to the current incident that the person is facing and on as a crime for. I would also note, and just to answer your initial question, this statute modification does require conviction for stalking. That scenario, the penalty would not be enhanced unless there was an active protective order, and then it could be. And it sounds like in that situation, there are so many complicated issues that would need to be unraveled and potential time hanging over that abuser's head in order to get them to conform their behavior to be part of, the conforming, the deterrent piece. And that would be, with additional time and a felony.
Okay, I have a question. So currently, the judge is able to consider prior convictions when sentencing, correct?
Yes, absolutely.
Okay, thank you. All right, thank you for being here. That concludes the hearing on SB 512. I believe we're going.
That's
is there
it.
another one?
Madam Chair, Madam Vice Chair, I was thinking like the air cut off and I was really on the hot seat, but that air feels good right now. So God bless you for that.
I ordered that. We're gonna call Senator Love next, SB 661. Thank you.
See you soon.
Yeah, sounds good.
You can bring your
Madam
pen.
Chair, may I bring up my panel?
Yes.
Would you like to come back? Have a seat. Thank you. Okay, thank you. Thank you. Okay. Get myself together. Okay. Good afternoon, Chair Davis. Oh, welcome back, Chair Bartlett, Vice Chair Davis, members of the Judiciary Committee. It's lovely to be before you today. Senator Sarah Love here to present SB 661. Senate Bill 661 is a narrowly tailored exception to our two-party consent rule in order to address very limited circumstances where the recording is of or part of a recording of the commission or attempted commission of murder, rape, or domestically related first-degree assault. This bill will allow survivors of rape or domestic violence and victims of murder, if they are killed, then after the death in the trial, or attempted murder, who record their attack, to be able to offer that recording as evidence at trial without being charged as a felony. In these cases where the evidence is often limited, having such recordings can be key to holding these attackers accountable. Too often now, victims come forward with these recordings, feeling like they can finally hold their attackers accountable, only to find out not only that these recordings can't be used at trial, but actually they could be charged as a felon. So SB 661 does four things. First, it creates an exception, a very narrow exception to our wiretapping law for recording these crimes. Second, it provides an affirmative defense to criminal prosecution in the event someone recorded because they reasonably believed they were in imminent danger of one of these crimes, of becoming a victim of one of these crimes, but then the crime did not occur. Third, it provides that the recording may be admissible as evidence if, one, it is a recording of one of the listed crimes, two, it is used as evidence in the charge of one of those crimes, and three, the person who was unknowingly recorded has at least 14 days, calendar days, advance notice of the intended use of the evidence. And then finally, it ensures that the recording may not be used as evidence of any other crime. Our two-party consent law is very important to many of us, I'm sure here in this room and also across the hall. We do not take exceptions to it lightly, and I bring this bill to you to help those victims of these very specific, narrow crimes. And with that, I ask for a favorable report, and I will turn it over to my panel.
Good afternoon again. Debbie Feinstein, Montgomery County State's Attorney's Office and Maryland State's Attorneys Association. On behalf of Senate Bill 661, good afternoon again, Madam Chair, Madam Vice Chair, and members of the committee. 661 has been, I would say, a long time coming. We have been working over a number of years with Senator Love, with Senator Simpson, with other senators in this room to try and, Senator Simpson, sorry, Delegate Simpson, other delegates in this room to try and make modifications to the wiretapping bill for the most serious crimes and to be able to hold offenders accountable. I'm going to give you a couple of examples that point to why this is so important. We had a case in Montgomery County where a woman was habitually raped and assaulted by her partner. And on one occasion, she managed to hit record on her phone and hide her phone under the bed, and it recorded the rape. In that case, not only was that audio not be able, we couldn't use it in court. But also, if the defendant had testified, we wouldn't even be able to use it to cross-examine the defendant about his conduct. And that was, again, an active recording of an active rape against this woman who had already suffered a great deal of abuse at the hands of her abuser. A similar story comes out of Calvert County. My colleague Rebecca Cordero reported that the victim in this case was raped by her estranged husband during a visitation with their 2-year-old daughter. The victim had hesitated to bring her child to this, but she did, and he had begged her to reconsider the separation. He pulled out a gun, put it to her head, and forcibly raped her while the 2-year-old lay sleeping in the next room. Because she knew of his violent tendencies, she turned on the recording function of her phone immediately prior to entering the house and recorded the entire thing. During the lead up to the trial, the defendant and his family disparaged her, called her a liar, claimed she was trying to get custody of the child, and claimed that they had consensual sex. And Ms. Cordero, the assistant state's attorney, had to explain to that victim why we couldn't use, or why she couldn't use, that recording that clearly demonstrated what happened. I urge a favorable report. Thank you.
Good afternoon, Madam Vice Chair, Madam Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of Senate Bill 661, which is so narrow. It is so narrow. We are talking about murder, we're talking about rape, and then we're talking about only first-degree assault, only in domestically related crimes. And it is that narrow because people value the all-party or two-party consent law. And so this is seen as a balance so juries and judges can get the truth in these most horrific crimes. It is a just thing to do. And I know every one of us can always pull out a parade of horribles and what ifs and, oh my goodness, this law is going to be abused, or this is going to happen, or it's, you know, a slippery slope, and blah, blah, blah. And in the meantime, we all have cell phones, and we have rape victims who have tape recorded, audio recorded their rape, and they can't provide this evidence of the truth. Now, if they videotaped it, that would go into evidence. And let me also just address the kind of specter of AI and deep fakes and all of that, and say that if she videotaped the rape, it goes into evidence. And you have cross-examination, you have the rules of evidence, you have all of these ways that we figure out whether or not that's a deep fake, whether or not AI was used. And all of that is going to apply for audio recordings also. This is not justice to say to rape victims, we can't use something that proves the truth of what happens, usually in private, usually when people are alone, and you are a felon. That is not justice. This bill is a good step forward, and the Maryland Coalition Against Sexual Assault urges a favorable report.
Thank you. Members, do we have any questions? Delegate Taylor?
Thank you, Madam Chair. And I believe this question is best served for Lisa, for something you just mentioned. If the video recording was muted, would it be accepted? That would still be accepted, right?
It would be subject to the rules of evidence. You'd have to prove that it's a fair and appropriate representation. But yeah, that could be admitted. I think the difficulty would be if you taped and recorded the audio. I think we would at least have to get Ms. Feinstein to say she wouldn't prosecute for the felony audio part. But yeah, I've heard prosecutors do that, say, okay, we can use the video, but we can't use the audio.
The audio piece. Wow. Thank you.
Thank you. Delegate Conaway?
Thank you, Chair. Thank you, Senator and panel, for coming in to testify. I've been working on a bill that deals with the camera issues. So in reference to murder, if you use an internal and external home surveillance system that includes audio and video, and someone is murdered, or if you're murdered out in front of your house or in your house, can that, under this bill, would that be admissible?
So Delegate, thank you for that question. It's a great question. Anything that's a recording in the public sphere, so like our audio right now, that's not currently prohibited from being admitted into evidence. So it sounds to me what you're saying is you've got a home security system out on the street, you're recording it, all of that is.
Well, you're recording your front yard and you catch your neighbor across the street.
Yeah, that's a public area, so that would be admissible now.
Now, so if you have a surveillance system that includes an internal surveillance, so like some people break in people's homes and they want to use the facial recognition to find out who that is. So if someone's in the house, they murder somebody. Then can you use that audio and videotape? Would that be admissible?
Under this bill for
yes.
the murder, yes, sir.
Thank you so very much.
Members, do we have any other questions? All right, seeing none. And I assume Ms. Rodriguez is not here.
She's across the street.
Okay, all righty. Thank you very much. And that concludes our bill hearing for Senate Bill 661. We're going to move on now. I saw Senator Jennings. I'm going to move on to Senator Jennings, please.
Madam Chair, may I do my second bill, or would you like me to come back?
I'm so sorry. I forgot. You do have a second bill.
I do.
And I apologize, Senator Jennings. And you have a sponsor only for Senate Bill 294. Is that correct?
Yes, ma'am.
Okay. Thank you. You may begin whenever you're ready.
Thank you, Madam Chair, Madam Vice Chair, members of the Judiciary Committee. Again, I am Sarah Love, Senator from District 16, here to present to you SB 294. You've previously heard this bill. Senator Guyton brought to you HB 450. And this bill would protect the identity of survivors of sexual assault or stalking. In 2024, this General Assembly passed legislation that protected the identity of minors who were victims of crime. SB 294 builds on that important privacy protection by, as I said, protecting the identity of sexual assault and stalking victims. Currently, the name of any adult victim of sexual assault or stalking named in a court case is easily accessible to the public. I don't know if you remember, but Delegate Guyton, when she came in, she talked about her office went around to all of the jurisdictions in our state and found that victims' names were accessible through court kiosks. So SB 294 would require that those names and information would be automatically redacted from public documents without forcing victims to go through the arduous legal process of petitioning the courts to protect their information. It would still allow defendants and their attorneys to have access to the information, and it would enable a court, upon a showing of clear and convincing evidence, to allow inspection of the documents with a victim's identifying information. It also allows a victim of sexual assault or stalking to petition a court to order redaction of a victim's identifying information from existing court records, so to go back. We added an amendment in the Senate that creates a process for disclosure to occupational health or health occupation boards when they're in the process of disciplining a member so that they can access that information. We often say that we want victims to come forward and to report their attack. We also want to make sure that as we do that, their identifying information is kept confidential, that it is kept private, and that they are granted that ability of keeping that information because they're afraid of retaliation or harassment. We should be doing everything in our power to ensure that Maryland shields the identity of these survivors. And I also just want to note that not only is it important to shield the identity of the survivors for their safety, but also to give them back a measure of control over their information when their control has been taken away from them. So to give them the ability to determine if and when they want their identifying information to be public. So with that, I thank you very much for your time, and I ask for a favorable report.
Thank you, Senator Love. Members, do we have any questions? All right, seeing none, that concludes our bill hearing for—
Thank you very much.
Yep, Senate Bill 294. We're going to call up Senator Jennings, and thank you for your patience. Senator Augustine, I will call you next.
Thank you, Madam Chair, Madam Vice Chair. For the record, Senator J.B. Jennings for Senate Bill 310. This bill it's pretty simple. It's kind of cleaning up a loophole with regard to our juvenile criminal records. And if you look at the bill, it's pretty simple. It's, the second page kind of sums it up. It's 4 sentences. Serious offenses are shielded with regards to our juveniles. But you know what is not shielded? Is traffic violations, such as, speeding, running a stop sign. Those are not shielded. And this actually came to me from a constituent. His son was riding one of those little electric scooters. A police officer pulled him over, and turns out he gets a ticket, and that's now on case search. And if you go and look, you can actually find all kinds of information on juveniles, 15, 16-year-old kids, and information. It has their date of birth, their name, and their home address all over case search. But, if they have a serious offense, those are all shielded. And what this bill is doing is saying, look, if we can shield serious offenses, we should be able to shield traffic violations. If they get in trouble, the police can still see it when they run a case search, as well as the judges. And that's what this bill's doing, is making sure that it's kind of a uniform fit for our children and protecting them. And that's what this bill does. So that's for favorable consideration.
Thank you very much. And was there any opposition in the Senate?
There is.
Actually, I was asking that with respect to the vote.
Oh, the vote? I don't believe so, but I don't think so. The chairman was here. I think he all supported. The opposition was, of course, from the court system with regards to technology, upgrading their system. But, they kind of oppose anything like that. But again, this is about child safety.
Right.
We just had a bill, 2 minutes ago dealing with stalkers, and, people are always looking case search looking for stuff, and, they can find somebody and they see that they're a minor. Who knows what they're going to do with it?
Yeah, it looks like it passed 45-0 in the Senate.
It was unanimous in the Senate.
Okay, great. Thank you. Delegate Conaway and then Delegate Moon.
Thank you, Chair. Thank you, Senator. Question. Can a car insurance company see a shielded juvenile violation?
I'm sorry?
Oh, I'm saying, can a automobile insurance company?
Can they?
Yes, can they see a shielded, if this passes, will they be able to see the shielded
I don't know.
minors?
I don't know if they're able to see beyond that or not.
Do you know that insurance companies do use minors' records when, some do, when issuing premiums for insurance, like on the parents?
They do. I do know that. But I don't know if they can see it or not.
Okay, but you think that the merit of the bill overrules knowing whether or not the insurance company should be able to see this?
I think preventing somebody trying to stalk a child is more important than, whether or not, an insurance company is going to charge a higher premium than that, or allowing an insurance company to figure out a way where they can actually go and research it and look at a.
Well, actually, I don't want to put that in a negative light, because actually that's what an insurance company does. If you have a child that's known to steal cars, and you have a car and you have insurance, you should have a higher premium, because this child has shown that they will take a vehicle
I agree
drive,
with that.
right?
If you got a lead foot, yes.
Okay.
As a child, you're getting tickets, you should be paying more.
Okay.
I mean, I know when I was a kid and I was turning 16, I knew my parents, the rate was going to go up. I got a 12-year-old son that I know in 4 years is going to cost me a lot of money. That's the price of having a young driver. But this bill's, we're trying to, again, you're telling me that if a kid gets pulled over and he's got a gun in the car, that could be shielded.
Yes.
But the fact that, he got, a ticket for going 35 and a 25, that can't be shielded. That's what I think is the problem with this.
Okay, I can see your logic. Thank you so very much.
Delegate Moon.
Madam Chair, lightning strikes. I had the same question as Delegate Conaway. Wow. But I understand the balance after listening to this dialogue, so I'll seek information offline. Thank you.
So that tells me I need to change the seating arrangement, okay? Because you guys are starting to think alike. No, that's okay. It's all good. It's all good. All right, Delegate Woods.
Madam Chair, so I'm curious with regard to what I'm hearing to be the intent of the bill, and that is that we want to protect the child from some other harm. Is there any documentation that talks about how children have been harmed because that information was not shielded?
I haven't seen any, but I will tell you this. Earlier this year, I had a personal case myself where I had a stalker through social media here in the legislature to the point where state police were involved. And they took it to the next level where they actually brought my kids into it. And it put fear in me. You know, come at me all you want. Don't bring my kids into it.
Gotcha.
But when I talked to this father that brought me this situation, you know, we talked about it. And I actually started doing case search of, you know, people I know who have kids who I know who've gotten in trouble, you know, who've gotten a ticket or something. And I'm like, that is out there that, you know, there's some bad actors out there that are going to sit there. You know, sometimes we do preventative. You know, we're more on defense than we are offensive, trying to figure out legislation, and it's trying to prevent this for something in the future. I don't want to be sitting here saying a case study saying, yep, we could have fixed this and saved this person, versus saying, hey, we could have passed this bill and actually prevented it. And I understand the judiciary is against it because of the IT situation. You know what, tell us how to fix it, and, you know, what money they need from the, you know, the appropriations in the Budget and Tax Committee. Tell us what we need to fix it, you know, financially, and we'll try to get them the money to fix it and do it right.
Yeah, I understand. I was just, because I actually agree with you in a comparison of, you know, the child carrying the gun and not being able to be, that information not being able to be shared. But I was just curious as to was there
No,
any...
I don't have one, other than the fact that just the cases of me looking them up and just kind of my jaw dropping saying, wow, that information is out there. That I was like, wow, you know.
Okay. Thank you. Thank you, Madam Chair. Thank you.
Thank you. The Vice Chair.
Thank you. Thank you, Madam Chair. The Judiciary noted some other opposition, some other, have you addressed those yet?
I don't know.
Okay, I'll share them with you. Do you intend for it to be prospectively, or you want them to retroactively review it?
No, I mean, I know this was some of the discussions that judicial proceedings had in the Senate, and I think they passed the bill the way it is, that I think it was going to be, I mean, look, it's the wisdom also of this committee. You know, honestly, I'm a graduate of this committee. I served 2 years sitting over here next to Delegate McComas many years ago. And that's part of, you know, you guys have the infinite wisdom here where you understand this stuff much better than me, being on a Budget and Tax Committee now, where you could say, hey, you know what? If we're going to pass this, let's fix it. Let's do it right. Here's the way we think we need to amend this thing and make it work. So I would leave some of that up to you.
Okay. Their other concern was that the young people would not know that when their trial dates were. They wouldn't have a record that they could go to.
Well, we changed that law a couple years ago where when you get a ticket, you have to actually apply for the court hearing.
Yeah, I understand, but you can go now and check to see when your hearing is, what courtroom it's in, and that information. I get it, it's fine.
That I don't know how that would work, because I think anybody who has a court case, you can still get that information, whether it's shielded or not. Because I've had other cases where, you know, you've had victims of domestic violence and stuff where stuff's been shielded, but they're still getting that information. I don't know where they're going with that, but.
Okay, thank you.
All righty. Thank you very much. Members, do we have any other questions? Seeing none, thank you, Senator Jennings. And that concludes our bill hearing for Senate Bill 310. We're going to move to Senator Augustine real quick with Senate Bill 1, and then Senator Washington.
Thank you, Chair Bartlett, Vice Chair Davis, and members of the committee. Senator Malcolm Augustine here on behalf of Senate Bill 1, which is very, very close to House Bill 155 that was presented in this committee by Delegate Williams, which is the Public Safety Law Enforcement Officers Prohibition on face coverings. There were a couple of amendments that make it a different posture than introduced here. The first was to require, instead of model, an adoption of a uniform policy, and also to preempts the adoption of other policies regarding face coverings by counties, municipalities, or law enforcement agencies of the state or political subdivision of the state. And then also another change was to make it a civil offense and also to provide for the foreign issuance and adjudication of citations under the bill. Madam Chair, you all have heard this obviously extensively. Those are the only differences. I think that we've put this into a fairly good posture, and I would ask for a favorable report on Senate Bill 1 as amended by JPR.
Thank you. Members, do we have any questions? Delegate Conaway?
Thank you, Chair. Thank you, Senator, for coming in and presenting the bill. Is a COVID mask exempt from this legislation?
Yeah, the COVID mask is a part of the legislation. There's health and safety. It was in the original bill, and it's still there.
Yes.
So that would be for health and safety. You would be able to wear a COVID mask.
Okay, thank you so very much.
Members, do we have any other questions? All right, seeing none. Thank you, Senator.
Thank you.
That concludes our bill hearing for Senate Bill 1. We're going to move to Senator Washington, and we're going to start with whichever one you want to start with. We can start with 865, or we can start with 351.
I have 351 in my hand, so we can start with that.
All right, let's start with 351. And Jamie Sexton? Is Jamie Sexton here? Okay, great, sorry. I should at least give you time to walk up.
No worries,
Alrighty.
I can be fast on these short legs.
Okay, well, whenever you are ready, Senator, you may begin. We do have a 3-2 rule, 3 minutes for the sponsor, 2 minutes for the witnesses.
30 seconds, all I
Okay,
need.
thank you.
Thank you, Madam Chair, members of the committee. For the record, Senator Alonzo Washington here to present on Senate Bill 351, which is a great bill that took a lot of hard work and for MIA and others. This bill is a consumer protection measure that ensures telematics-based pricing is transparent, accurate, and accountable with meaningful oversight by the Maryland Insurance Administration. For all those who don't know this, but telematics programs use in-vehicle devices or mobile apps to collect data on how, when, and where a person drives. And insurers use that data to increase, decrease, or sustain premium pricing. Telematics programs are growing quickly here in the state. MIA, who's here with me, has surveyed the largest carriers in the state, representing 90% of the market, and found most now offer telematics, this program. Consumers enroll because they believe they will save money. That's what's sold to you on so many different ads. But MIA's report from MIA found that the outcomes are mixed. There's only a 31% chance using telematics here in the state, based on their report, that you'll see your premium decrease. About 24% under their report saw an increase. About 45% saw no change at all. Now, we are seeing this show up in real consumer harm. It was 811 consumer complaints in an 18-month period, about 12.4% of all passenger auto complaints, some involving increases of up to 42.5% of their premium per month. Right now, many policyholders can't easily access that underlying telematics data. That means the data that they collect from you, that you sign up for, you cannot right now have access to that fully. all that data that they use, these car insurance companies use. You cannot have access to that data. You cannot challenge errors because you don't have access to that data. You know that there's plenty of errors because this program is very new. A lot of cars use it. A lot of low-income insurers or insureds use it because they believe they're gonna have a lower price. But when you step on that brake too fast, your premium goes up. When you make that left turn too sharp, your premium goes up. If you drive late at night, your premium goes up. You have to be a perfect driver, in some cases 80% or more of a great driver. Madam Chair, this bill just requires insurers to disclose that data requires insurers to provide the policyholder the data being used, and establishes a process to correct the appeal. It strengthens MIA's oversight of how insurers collect, process, and use this data. It prohibits insurers from initiating premium increases based on telematics increments of less than 6 months. Right now, they increase it every month because of this program. Most of our premiums are 6 months. Under this program, they're able to increase it every month based on telematics. I'll stop there because I know I went over my time, Madam Chair, but this is a really easy bill that was proposed, and there was a study done by MIA, who supports this legislation, to move this bill forward because it protects consumers and protects us and ensures that folks are able to access the data that these insurance companies collect on a daily, hourly, minute basis when you're driving your car.
Okay.
Thank you, Madam Chair.
Thanks. And people may have questions. Members may have questions.
I'm done.
Okay. Next, please.
Thank you, Madam Chair. For the record, my name is Jamie Sexton. I'm here on behalf of the Maryland Insurance Administration to convey our support for Senate Bill 351. This bill addresses the increasingly prevalent use of telematics systems in private passenger automobile insurance. These systems, which measure the operation of an insured vehicle, offer potential benefits, but also raise important questions regarding consumer protection and transparency. Senate Bill 351 takes steps towards ensuring that Maryland consumers are protected when their driving data is being collected and used by insurers. First, it would mandate that insurers clearly disclose to insureds what specific data about their driving habits and vehicle is being collected through the system. This right to know will empower consumers to understand how their insurance rates may be influenced by this data. Second, the bill would require insurers to establish a clear and accessible process by which insureds can contest the accuracy of the data collected. The MIA has received consumer complaints highlighting the need for such a process. For example, a telematics system might mistakenly attribute distracted driving behavior to the policyholder as a result of a passenger using the driver's cell phone. Senate Bill 351 would ensure that there's a mechanism by which policyholders can address such errors in the data. The bill also directs the MIA to adopt regulations limiting the types and amount of data that PPA insurers can collect through telematics, recognizing the need for regulatory oversight to ensure that data collection is fair and relevant. It also permits the MIA to require insurers to implement and report on their telematics governance plans, further enhancing accountability. While we don't take a position on the provision regarding mandatory telematics programs, we strongly support the enhanced transparency and consumer recourse measures within the bill. In short, Senate Bill 351 offers important protections for Maryland consumers in an evolving insurance landscape. By promoting transparency, establishing avenues for data dispute, and empowering the MIA to provide regulatory oversight, this bill will foster a fairer and more understandable insurance environment for Marylanders. For these reasons, we request a favorable report. Thank you.
Thank you. Members, do we have any questions? Delegate Woods?
Thank you, Madam Chair. Thank you so much for your testimony, and I do think this is a good bill. My concern is, and certainly would like to know, I don't know if you can even answer, so my insurance company actually said to me, you know, can we do this? And I said no. My insurance jacked up. So I'm concerned because not only do you not have the accurate information, you know, my concern is where I live, my senator is here, and a street that I frequently drive, I always have to brake quickly because people around me are driving crazy. And I know that these are things that can get you in trouble when you may be being a defensive driver, right? And I'm not going to sit here and say I don't always go above the speed limit because I wouldn't be telling the truth. But way beyond that are the other concerns. A dog runs out in front of my car and I hit the brakes. A child runs out in the street. Like I said, constantly being backed up in traffic, you know, trying to avoid other drivers. All of these things, based on what I heard you just say, would automatically increase our insurance, and there's nothing to tell us. You understand what I'm saying? That we can say, that we can argue. But the fact that they go ahead and increase your insurance if you say, no, I don't want you to do this. I mean, I'm not sure that your bill really addresses that, but that's my concern. How would you respond to that?
Well, thank you for that, and I appreciate what you're saying, and amen to not the driving situation of going over the limit. You know, you're right. This bill does not cover that point when they sell to you at the beginning of you doing your trying to find a quote. And if you click off of telematics, then your increase goes back up because they want to use that as an incentive for you as a driver's discount for you. And so that is an incentive. And so if you use it, then yeah, we'll give you this discount if you use it. But as you enroll in the program, so this bill doesn't touch that piece about that piece at all. It doesn't touch that incentive-based piece. What it does touch is if you do choose to use it, and you get that incentive, we want you to keep that incentive. But this bill covers if you use the telematics and if you, like you said, you had to stop because of a dog was in front of you, or folks are speeding and you had to slow down, you had to drive a little slower that day, or something else happened in there, or if, as it was said by MIA, if someone else is using your cell phone in your car, but they mistaken that for you using your cell phone in your car and they ping you. Now they use that data for that whole month to determine what your next premium is gonna be. So it's not that they increase it automatically during that month, but they use the aggregate of the data that they have during that time, and then they will increase or change or sustain your premium. And a lot of folks, like you said, because of that $50 off a month, or because of that whatever it's amount that could be significant, you go into that program hopeful that your rate doesn't increase every time you make a mistake. And that's not what insurance is there for. They should be there in case I get in an accident, and if I need them or if we need them, they're there to help us in that circumstance. So it does not cover that part about the incentive base for the program.
Madam Chair, thank you. So a second question for clarity, that increasing on, you know, they do this on a monthly basis. So if 1 month you have this incident and it increases, do they ever go back and decrease it?
I don't know. I'll actually, MIA, if they have data that attests to that. But I guess it could if you've had a good driving history during that period of time, and maybe you didn't drive your car. Maybe they might during that month. Maybe they might decrease it. That's neither here nor there. What this bill covers is that there's more oversight by MIA for these programs, that there's more oversight for you as the consumer, so you have access to that data. You know, in my car, when I drive and I turn this corner, my car sees a car in front of it, and because that car is parked, it dings and makes a noise, and that right there could be another signal of my premium decreasing. And I don't have a way right now to appeal that or to question it because I don't have access to that data that these insurance companies have access to data. This is about transparency, accountability, and ensuring that we're protecting our consumers. That's what this bill is about. MIA did their homework, and I proposed the bill ahead of schedule last year, and it didn't make its way out. But because we have this report now, we're able to really helpfully move this bill forward and make sure that consumers here in the state feel protected.
Last, can I have just one more, I promise?
Just one?
Just one more, I
I'll be more
promise.
succinct, Madam Chair.
No, you're fine, it's me. The last thing for me is I am sure I am not the only one in this room that uses my car as my office. And so I am frequently on the phone, but my car has, you know, the way that I can use my phone. Hands-free, thank you. Where I can use my phone through the car on a hands-free device, and I don't understand how we can be dinged for something like that when I'm still watching what I'm doing. You understand what I'm saying?
Yeah, absolutely.
But the fact that I'm using my phone is considered a hazard. Can either of you address that?
I unfortunately am not able to speak to the inner workings of each telematics program. Some carriers use apps on the phone, which would obviously take record of when you're on a call. I do not know if they're able to differentiate between hands-free calls and calls that you're physically making. I think that would have to be a question for the carriers, but I will note that I would think that it would probably vary from carrier to carrier.
All right. Thank you, and thank you, Madam Chair.
Of course. Delegate Conway.
So Senator, how do the insurance companies get these telematics from your vehicle?
It's a handheld device, or some of them are built into the car.
Some of them are built into the car?
Yes.
Okay, so, and then you can opt out, is that correct?
Yes, you can opt out.
And then you could not opt in, is that correct?
You cannot opt in.
Yeah, you said like you signed up for it, so you could just not sign in.
Correct, yes.
So my question I asked before that was, once you get in and you see that your insurance is fluctuating every month or every 2 months, can you say, hey, I want to opt out of that?
Yeah, but you still owe what you owed, and you still didn't have access to the data that you had in that previous month. There's still no oversight of that program like MIA says they need to make sure it's a credible program. So even though you opt in because you wanted to have that initial decrease or discount, yes. You still would be covered under that month and still would have to pay, although you can leave the company. Some premiums you can leave whenever you want. I think most of them you can leave.
Okay, so if I'm insured by one company and I opted in and my premium goes too high, if I go to another insurance company, do the insurance companies share that data?
I don't have a definitive answer on that, Delegate, and I wouldn't want to give you wrong information, so I would love to go back internally and discuss. I believe the answer is no, but I don't want to say that with 100% certainty without my lawyer telling me that.
So therefore, you'll get back to me with the answer. Thank you so very much.
Delegate Taylor.
Can I just say something before? There's no prohibition for them selling this data, though. They can sell the data that they collect. They can do that.
Yeah. Thank you. Okay. Delegate Taylor.
Thank you, Madam Chair. Thank you, Senator, for bringing this bill. Can you address the provisions in the bill that deal with the data potentially being unfairly discriminatory? Is that something that we're afraid might happen, or is that something we just want to make sure that when there is oversight, we want to avoid data that might be unfairly discriminatory? Any thoughts on that part of the bill?
I don't know if discriminatory is the right word. We want to make sure it's fair and accurate is what we're trying to get at here on this bill. So ensuring that the consumer has access to the data and allowing MIA to promulgate regulations for them to have access to that data, I think is what we want, so that there's a vehicle and a method for an appeals process if a driver feels like they have been wronged, and they did, as Delegate Wood said, and they had a reason for stopping. They had a reason for driving late at night. They had a reason for answering the phone. It was in case of emergency. They want to be able to have an appeal process, which is some of the MIA recommendations. So I don't think it's discriminatory is what we're looking at here. We're looking at fair and transparent access to data. That's my own data as a driver.
Right, okay.
Because they use that data to determine your insurance premium.
Right.
No, I didn't get in an accident that month, but my insurance premium went higher because of the method in which I drove that month. And I believe that's unfair, and I believe that that's not right, and I believe it shouldn't be month to month. If they're going to increase it, allow the premium to exhaust and increase it at that point once the premium has been exhausted. I believe that's a fair and balanced approach to this program if folks determine they want to opt into this program.
I understand that, and I have a question for Ms. Sexton.
Sure.
Yes, ma'am.
There are companies out there that use telematics only, right? Aren't there some companies? I've had a lot of discussions on this bill, and I learned that there are some companies that might use telematics only. You think if we pass this bill, it would be in any way unfair? These telematics only type companies would go out of business, maybe?
When you say telematics only, you mean that's the only way that they calculate premium?
That's what I'm thinking, yeah.
So we can certainly take that back and see what that looks like. You're familiar with specific companies that utilize telematics only?
I think I'll ask the next panel maybe too.
Well, I guess also my question there would be, even if they utilize telematics only, wouldn't we want to ensure guardrails on the data that they're using for those programs? So I understand that there would be some concerns about how certain provisions of this bill could potentially impact the offering of such programs in the state. But I guess my counter to that would be, those provisions aside, the provisions that are dealing with transparency and fairness and ensuring that consumers are aware of how their data is being utilized to affect their premium through such programs, don't we want to ensure those guardrails? So I think what you're getting at is a couple of provisions within this bill that I think potentially have impacts, but I think what I would really highlight there is, even the programs that only offer that, don't we want to ensure that consumers are still being treated fairly and appropriately, and that we have appropriate jurisdiction over how those are impacting Marylanders?
Sure, great, thank you. But Madam Chair, may I have one more question?
Can I follow up on just a quick question real quick?
Sure.
No,
Briefly,
go ahead.
just briefly though.
Well, this doesn't ban telematics in the state. It does not ban.
Okay.
This is free. They can use it whenever they want. It doesn't say how much what rates they set for the use of telematics. They can set whatever rates they want. This doesn't do that. This just places guardrails and encourages transparency.
Okay, and then thank you for that extra. And for Jamie, also, you mentioned there are parts of the bill, there's a part of the bill that you really don't support. Did you say that, or did?
It's not
and
that we
then,
don't.
Wait a minute, because
I
I
apologize.
probably limited my number of questions.
Yes,
I'm gonna just combine them, okay? The senator said that there was 811 complaints in just an 18-month period. Do we know if those complaints were spread out over many different insurance companies, or are there a few bad actors out there?
So I'll start with your first question. It's not that we don't support that provision. We take no position on the provision that relates to mandatory telematics programs. So there's a provision in law right now about whether or not an insurance company can require the use of a telematics program. And this bill alters that. And we have no stance on that position. We very much view that as a policy decision and the will of the legislature on that. We take no position on that whatsoever. Your second question about the 811 complaints, I do not know offhand how many companies were involved, but I can certainly find that out and let you know.
Thank you.
Yes, ma'am.
Thank you, Madam Chair.
Thank you. So I was looking over the report, the MIA, it looks like a market report that you all did. Yeah, a telematics survey report. Do you think you have enough data or enough information yet to regulate, to create these regulations? This was just done in 2024, it looks like.
The report was done, yes, ma'am, and I will say that, as you know, the senator and I have mentioned, telematics are still an evolving program, but I think that with all technology, evolution is going to be a constant.
I understand that. What I'm getting at is, do we know that, and this could be for you or the bill sponsor, do we know that there is the ability to provide this information to drivers, the data that we're asking for?
The ability to provide it?
Yes.
Yes, ma'am.
Okay.
I think the details of what that looks like are what we'll have to work through, but yes, ma'am.
Okay, so that sharing process could possibly be something similar to my utility bill or my phone bill or something like that. Is that right? Now, one thing I didn't understand, Ms. Sexton, that you mentioned was about the phone. Actually, you both mentioned it, about the phone and not knowing which phone and could it be the passenger, et cetera.
Yes,
is that because we know that insurance companies are using a cell phone tower? I mean, why is that? Is that how they're getting the wrong information? Are they using a cell phone tower and saying that the cell phone was used at this particular time between when someone was driving? Or how do we know that information?
That's a phenomenal question, Madam Chair. So there are different types of telematics programs used by carriers. I think the majority of carriers these days use an app. Some carriers have the telematics program built into the car itself, so more advanced cars have that automatically built in. And some carriers still utilize the plugins that plug in under your dash in your car. I would say that the plugins are becoming less commonly used these days, more in favor of the apps, but I think there's still some carriers that utilize those. For the programs that are on the phones, they have access to your phone data. And so because they are, I don't know to what extent.
Wait a minute, let me just make sure I understood that. You're saying that the ones that use the phone, they have access to your phone data?
That was a misframing,
Oh,
but they
good,
can
okay.
tell.
'Cause that just made
No, ma'am.
all antennas go up.
Because they're
Okay.
on your phone, they can tell when you're using your
Thank
phone.
you. Okay.
Yes, ma'am, I
Gotcha.
apologize. That was a poor way to phrase that.
No, that's fine, that's fine.
And so they can tell when you're on your phone. What they can't tell is, are you a grandmother with your grandchild in the back seat and you've given them your phone to play a game to get a few moments of quiet while you're taking them to Target? And so that's one of the big provisions in the bill that we really like, is the need for an appeals process. So there are certainly instances where that's the case, where someone's using your phone in the car, but the app has no way of knowing who's using the phone, and we don't blame them. There's no way to know that. And so ensuring that there's an appeals process for instances like that is imperative.
Two more quick questions. So appeal to whom?
The carrier.
So appeal to the carrier, and just simply, if you have the opportunity to present data to show that, one, it wasn't my phone, or two, it wasn't a real phone call, it was just dibbly-goop or something like that.
Yes,
Okay.
ma'am. Some apps currently have a process like that, but they're
Okay.
limited to just saying, I was not driving at this time, I was just a passenger in the car, because that is another instance where the app can tell that you're moving, and so that you're in a car, but they can't tell that you weren't driving, for example. So if I got dinged every time that my husband was speeding, I would be uninsurable at this point. So.
I get that, I do, I get that. My second question would be, so in doing the regulation, so MIA already has certain enforcement mechanisms that you already have in place for various violations, not necessarily telematics, or did I pronounce that correct? Telematics? Yeah, telematics. Not necessarily for telematics, but for other things. So there is an enforcement, you all have an enforceability mechanism. Okay.
Yes, ma'am.
So if there were a violation, if there were a carrier who is in violation of these regulations that you all put in place, you would have an enforcement mechanism as well.
Yes, ma'am, Madam
Is
Chair.
that enforcement mechanism only through financial means, or what is the means that you all use?
The penalty, I believe it would be a financial penalty. I'm not sure what we have above and beyond that, but I
Okay.
can certainly get back to you.
Okay, no, that's helpful. Thank you very much. The Vice Chair.
I think John was first, but, okay, thank you, Madam Chair. Ms. Sexton, you spoke of the insured not having access to the data, okay, correct?
Yes, ma'am.
Okay, so is there any prohibition against the insurance company using the data that they've collected to make liability decisions?
I don't know the answer to that.
So Delegate Woods down there said sometimes she speeds. We have a contributory negligence state.
Yes, ma'am.
She gets into an auto accident. If they can prove that she was doing 57 instead of 55, they could deny her coverage for the accident and make a liability decision based upon it. Have you seen that?
I would have to check with our complaints teams. I am not sure the extent to which carriers do or do not use telematics data with regard to liability decisions. That is not something that I'm able to speak intelligently on, but I can certainly get you information on it, ma'am.
Is it currently prohibited by law?
I don't know the answer to that.
Okay, thank you.
No. Answer is no. Answer is no, no, no.
Delegate Cardin.
Thank you. Thank you, Madam Chair. Thank you very much for coming. It sounds like you want some disclosure, you want some information.
Correct.
So if at the bare minimum you get the information, or the consumer gets the information they want, it sounds like you guys would see that as a win. Is that fair to say? Or not?
Yes, I think it's a
Okay.
win. I think it's a win for consumers to have full access to the data that this company collects.
I happen to use the Drive Safe and Save app with State Farm, which I guess is sort of like telematics. I'm not sure it's exactly like it, but maybe it is.
Yeah.
I get every once in a while, I actually look at my app, and I get a monthly report, I can tell that they're mad at me for speeding on this day, they're mad at me for using my cell phone on this day, which is another issue that we obviously need to deal with. That might be a legislation for another day about, because my child is constantly in the back. The question is, aren't I already, now maybe State Farm is just one of the ones that you like, but aren't we already getting the data that you're looking for? Is that not?
I mean, we're talking about all, I mean, look, so let me just make something clear. So you're right. So that drive safe and save, I mean, that's what telematics is in many cases, is disguised as a program. It's not always called telematics. You're not going to see that show up on your bill saying telematics, but that's what the tool is to measure the usage. Yes, we want that type of data, but we want folks to have access to that data. And for all companies, not just State Farm or whomever else that offers that type of data to their consumer, but we want them to be able to appeal that. There's some cases where you can't appeal that data that's there.
So if and I have no idea whether I can appeal it because I've never tried to, but it's an interesting concept. But if you see that your rates go up because, and you call your agent, you say, why the hell my rates go up? And you say, well, because you were speeding on March 30th, and therefore, your rates went up. You say, well, I want to get rid of that program. They can't require you to keep the program, right? They have to release you from that telematics program, or if they're a telematics only, they can just tell you to go find a different carrier, right?
Yeah, I think that goes back to Delegate Davis's question about liability. Can they change it or not? Yes, they can deny you if you're speeding or changing your.
No. So State Farm, if I say to State Farm, you just raised my rate $7, I don't want this program anymore. Can I cancel it? And the answer is yes. In fact, I think you testified that yes. So you're not required to use this program, right? No. So you can do it. And in fact, if you're talking about every 6 months, but if you wanted to cancel it in a month because your rates went up that month, you can cancel it immediately, can't you?
Yeah, but you also still use the program. You still had the program, no matter you still agreed to initially to doing it, and then you use it for that period of time.
So you're talking about that for that month. You wanted to get the $7, $15 taken off for that month.
I'm not trying to get anything taken off. What I want is transparency and accountability in the use of this tool.
So I'm
not asking for the $7 to be taken off or any type of amount. What I'm asking for is transparency and access to data and information, and for there to be an appeals process during that time period, so you have as a consumer the ability to do those things.
So I think this is my last question is, so you had mentioned that there were 31% of the insured had a decrease, 24% had an increase, and 45% there was essentially no change at all based on people who started the telematics program.
This is according to the, go ahead, what's your question?
No, according to the.
Yeah, this is according to the MIA study, which I thought was a very
So let me ask, so I'll ask MIA that question.
Wait, can I finish my answer?
Sure.
MIA conducted a report, which was a long report that they've done. They studied this process. They surveyed over 90% of the industry, the folks that covered the 90% of the market itself, and they showed that you have only a 31% chance to see your premium decrease. Only a 31% chance to see your premium decrease. You have about a 24%, they saw an significant increase. And then 45% saw no change at all.
Okay, so my question for MIA.
Yes, sir.
Is you said 812 complaints?
811.
811 complaints. How many of them were people, the 31% who had a decrease or the 45% who didn't change?
I honestly couldn't tell you that off the top of our heads, but I can certainly find out for you, Delegate.
It would surprise me if any of them were of those, and only the ones who were increased, possibly because of their driving behavior. Okay. Thank you. I appreciate it.
Delegate Conaway.
And Senator and panel for coming in. So in reference to this telematics, is the GPS data also captured with the telemat?
Yes.
And if you have the telematics hooked up to your car or in your car, part of the computer system, how would they know if you're on your phone?
They wouldn't be connected to your phone, so they wouldn't know.
So, but
So there's some companies that only use it for your phone, because maybe you have a 1967 Camaro, and you won't have that on your car, but you have your cell phone with you. That will be the form of that that will be used as a tool to measure where you go, how fast you drive, anything of that nature. And that's when you start picking up your phone, and your child picks up your phone, or anything of that nature. And can I just make something very clear, though? It was 811 consumer complaints to MIA about telematics base rate increases in an 18-month period. Let me say that again. Of the 811, those were the complaints to MIA about telematics base rate increases in an 18-month period. So all 811 people that made a complaint, it was about telematics and it was about the rate increases. Let me make that very, very clear here.
And in order for them to collect this data, if you have the app on your phone, do you have to turn your phone on when you get in your car, or how does that work?
I would presume so, but you never know with these iPhones.
Right. Thank you so very much, Senator. Thank you.
That's funny.
Members, do we have any other questions?
This was great.
All right, thank you very much.
Thank
That
you.
concludes this panel for Senate Bill 351. We have some folks who are testifying unfavorable. Robert Enton, Nancy Egan, and Gina Rotuno. Yeah, great.
Okay.
Thank you, Madam Chair. Robert Enton on behalf of the American Property Casualty Insurers Association. And with all due respect to the sponsor, we're in very, very strong opposition to this legislation. We've talked with a number of you about it. We had the bill last year. Basically, the bottom line for the insurance industry on this bill is that if this bill passes in its present form, and the requirements that are in this bill are imposed on companies that offer telematics, those companies will no longer do business in the state of Maryland. It's that simple. No state in the country has adopted anything even remotely like this to regulate the telematics in the insurance industry. If you want to have telematics, that's your choice. We have hundreds of companies that offer insurance in the state of Maryland that offer a variety of different policies at a variety of different costs, and you get to choose what you want. And if you choose telematics and you decide you don't like it, then leave it and go with a traditional company. But I don't think what we want to do in this day and age is pass legislation which distinguishes our state from any other state in the country and says to people, you know what, you can't get telematics in this state at all because of a piece of legislation passed by the Maryland General Assembly. So that's my testimony. Madam Chairman, I have a bill that's coming up in 5 seconds over in JPR. If I could be excused, any questions about what I said, you can ask the other panelists and they'll answer.
All righty, will do.
Thank you very much.
Safe travels. Okay, whoever's ready. Thank you.
All right, good afternoon, Madam Chair and members of the committee. Thank you for the opportunity to speak today. My name is Gina Rotuno, and on behalf of the National Association of Mutual Insurance Companies, we most respectfully oppose Senate Bill 351. Telematics programs are a valuable voluntary tool that help align premiums more closely with actual driving behavior. By rewarding safe driving, these programs encourage better habits on the road and often provide meaningful savings to consumers. Participation is optional. Drivers are informed about the data being collected, and they can opt out at any time. As drafted, the bill could have unintended consequences that reduce choice and innovation in the auto insurance market. SB 351 risks limiting the availability and the effectiveness of these programs by prohibiting carriers from using data from these programs to cancel, refuse to renew, or refuse to underwrite a policy. Limitations on how telematics data may be collected, used, or retained could diminish the predictive value of these programs, making them less beneficial for both consumers and less viable for insurers to offer in Maryland. We're also concerned about provisions restricting premium adjustments within the first 6 months of a policy term. As written, this language may unintentionally interfere with routine program administration. For example, adjusting participation discounts when enrollment requirements are not met or when a driver enrolls midterm. These adjustments are administrative, not punitive, and are intended to ensure fairness and consistency across policyholders. Existing oversight by the MIA already provides strong consumer protections. Telematics programs can continue to evolve responsibly without additional statutory constraints that may limit consumer choice or stifle innovation. Finally, the bill would impose some of the most extensive restrictions on telematics-based auto insurance programs in the country. It may prompt companies to reevaluate the cost-benefit of their current offerings and could discourage others, particularly smaller insurers, from offering these programs at all. For these reasons, we must respectfully oppose Senate Bill 351. Thank you.
Good afternoon, everyone. My name is Nancy Egan with the American Property Casualty Insurance Association. I submitted some very extensive written comments about the bill. We are in opposition. As mentioned, this would be the most regulated telematics legislation throughout the country. Some things that need to be cleared up. First of all, the MIA report. Let's go back to that. The MIA report only looked at policies at renewal, not the initial application process. So that when they renewed after 6 months, they then looked to see what happened to the premiums to those people that were initially signed up for telematics. When you shop around, you make choices. And I'd like to clear up one other thing. If you choose not to accept telematics, they cannot raise your premium. That is incorrect. I wanted to clarify that right away. And I'm sorry that that happened to you, and I'd love to hear a little more about it. So you shop your insurance. A lot of the companies say, we're going to give you a standard rate and we're going to give you a big discount if you sign up for telematics, because we know that telematics improves your driving. Then at renewal, they remove the initial discount and then apply how you actually drove. So those 45% that did not see a change in the premium are now actually getting the rate that they had signed up for with a 15% discount. These people moved to telematics because it was saving money for them initially. Then the other percentage actually got a further discount with the plan. So I think that needs to be clarified. In addition, the way the bill is written, there are companies here in Maryland, there's 126 companies operating for private passenger auto, 54 are offering telematics. There are several companies that only offer telematics. The way this bill is drafted, it says that they would not permit them to operate in the state if you only offer telematics. So it could be a single company that's all they do. This is all they do. You've seen advertisements for these companies. There's so many other issues with the bill, and I'd love to answer any of your questions for some of the things you heard previously. Thank you.
Thank you. So Delegate Conway and then Delegate Carter.
Yeah, thanks, ma'am. I would like to get information on the companies that use telematics only. And furthermore, to the first person that's at the panel, you said the information collected can be used to cancel a policy. Did you say that?
In terms of not allowing that.
You said cancel, right? No?
This bill would not allow telematics data collected to be able to use cancel renew a policy.
So it would not be able to use?
No,
right,
according to this bill.
But right now, they can use
that.
The information to cancel a policy.
Yes.
Yes, thank you. And what I was trying to get to was when a person signs up for the telematics and think they're getting this great discount, are they made aware of the fact that their policy might be canceled because of weird driving patterns that come up?
My understanding is yes, they are aware
So
of
they
it.
are aware that their policy can be canceled?
Yes.
Okay. Thank you so very much.
Yeah. Delegate Cardin.
Thank you very much for coming to testify. So just a couple quick questions. First of all, can these companies share the data that they receive?
Let me explain. Some of the companies use a third-party vendor to collect the information. If the information is aggregated, they're not going to take a single incident of breaking to raise your premiums. What they're going to do is look at whether or not you're breaking frequently, which quick change of lanes is also something. You asked about the phone. They are able to distinguish when you are using your device, your screen, hands-free phone, or not talking on the phone or texting. They can distinguish that. Many of them actually in the app permit you to say, hey, I was sitting in the car, I was not driving. Or they also say you can call the company and say, listen, I even have an example. Someone was on a bicycle and they had their phone in their pocket and they were moving all around. They were actually able to call the company and say, hey, I had my phone in my pocket. I didn't realize I had the app turned on, and I was riding my bicycle. So, you can call the company to dispute the information. So we say we understand we need to have a process to dispute the information, and I know that companies have that in place. They have in the bill something about appeals process. I'm not too sure what appeals process is. There's already, all companies are set up for the complaint process. Anyone out there can reach out to the complaint unit, the consumer division of the MIA, to file a complaint about whether it's telematics or a premium increase on your regular policy, or you're not happy with the way a claim was adjusted. This is already under the regulatory authority of the MIA, and telematics is just one program that is under the authority of the MIA. And one other thing, we are already subject to legislation in Maryland for all insurance companies that rates cannot be unfairly discriminatory, excessive, and they have to be able to support the financial status of the company. They can't be too low where they're looking at their financial status.
Okay, thank you. That was very helpful information, but didn't answer my questions. My question was, can these companies share data? And if they can they sell data? Do they sell data? Should we prohibit them from selling data?
I apologize. I was really on a tangent there, and I'm really sorry. Okay, when you move from one company to another, we don't share that data. There is some data that we have access to on a national basis. It's the consumer CLUE reports, which means if you get an accident with your insurance company, let's say State Farm, and you move over to Geico, we do share information about at-fault accidents, and we are able to pull up your driving records from the MVA. But when you move with your telematics information and you say, enough's enough, I'm a really bad driver, I'm gonna go to another company, that information does not go on to the next carrier.
I'm gonna go back to the liability question that Delegate Woods and Delegate Davis were asking about. Can this information be used to determine, to help on litigation regarding liability or contributory negligence?
I would have to say to you that there was a bill this year in Virginia that would require, if you were in an accident, whether you were at fault or not at fault, that you would have to provide the police officer your information about who your carrier was, and the I think it's called the MEI information, as well as the insurance companies must disclose if their driver was enrolled in a telematics program, and that would be either if you were at fault or not at fault. That bill failed. It seemed to me that they were trying to make that discoverable in Virginia, but I don't know if that's true in Maryland, but that's a good question. Can you request whether or not the driver was enrolled in telematics at the time of the accident?
Okay. So it's still an open question. Okay.
Yeah, it's still open question.
Then just leading up from that is if State Farm has my data, and my data shows that I'm very aggressive and that I'm constantly getting close to people's rear ends and almost hitting them.
Right.
Can they sell that data to a company that does whatever body work, or sell that information to potential industry that may be able to benefit from knowing that I might be getting into an accident real soon? Is there anything that stops them from doing that?
I would need to check with you, but from what I understand, and I've testified in other states, that information, when it's aggregated and it's de-identified before the third-party vendor, it's de-identified, so it's not specifically for you, but
right. So it's disaggregated, so we don't necessarily have the individual, as you said before, the individual information about this particular driver.
No.
That stuff is not communicated anywhere else except in determination of a premium for that specific policy. Is
exactly.
that fair to say?
Yeah, you're taking out the personal information and saying that we're seeing a trend that people that break on a constant basis, that insurance companies can see that might increase the rate of accidents.
I have lots more questions, but we'll talk later. Thank you very much.
Thank you.
Thank you. So I'll go to Delegate Taylor, and then Woods, and then Embry, and I have a couple of questions.
Thank you, Madam Chair. Thank you, guys.
You know, I'm sorry, Ms. Pachman, I forgot to let her testify.
Oh,
Ms. Pachman,
sure.
I'm so sorry.
Okay.
Let's go ahead and because you're unfavorable. Let's let you go ahead and testify so that you can join in this robust discussion.
No, I was enjoying having all of the questions asked before I chimed in, but okay.
All righty. So whenever you're ready, please provide your testimony. Thank you.
Okay, great. Good afternoon, Chair Bartlett, Vice Chair Davis, and members of the House Judiciary Committee. I'm Lauren Pachman with Allstate. Thank you for the opportunity to speak in opposition to SB 351. Our opposition to the bill is based on several issues. First, we think SB 351 is too broad. This bill would impose the strictest constraints on auto insurance telematics in the whole country. The MIA's own data from its 2025 report shows that the bill isn't necessary. The number of auto policies enrolled in telematics programs has been steadily growing because consumers value them. The report found that 75% of users get either a decrease or no change in their premiums when they participated in telematics programs. Telematics is also the most powerful and accurate mechanism available for consumers hoping to lower their premiums. They choose to enroll in these programs to save money. And the percentage of complaints the MIA gets on telematics is commensurate with its market share, showing that consumer complaints don't disproportionately involve telematics. Also, by incentivizing good driving, telematics makes Maryland's roads safer for everyone. The primary value of telematics programs for insurers is that it provides a near real-time feedback loop, allowing them to adjust pricing in keeping with existing Maryland law and regulation. It also gives drivers extra influence over the cost of their insurance by giving them timely feedback, positive or negative, on their driving patterns. The bill would prohibit insurers from using the 45-day notice of premium increase, or NOPI, process to issue telematics-based premium increases more often than every 6 months. This change would lead to bigger, less predictable increases at renewal time, which will make telematics less useful for insurers and make premium increases harder for consumers to bear. If a safe driver gets a discount soon after their telematics program begins, they'll be motivated to keep driving safely. If a risky driver gets a midterm NOPI, they'll be motivated to drive more safely. Under this bill, though, instead of a midterm NOPI, a risky driver would get a rate increase several months after the risky behavior. That'll lessen the perceived connection between the bad behavior and bad outcome and make the rate increase less likely to persuade that driver to improve their behavior. Finally, the MIA is currently in the process of developing telematics regulations. To reduce market uncertainty, it makes sense to wait and see how the MIA regulations function before stepping in with new law. For these reasons, we respectfully request an unfavorable report on SB 351. Thank you.
Thank you. And now, Delegate Taylor, I hope you have remembered your question.
I do. I do.
Great.
Thank you, Madam Chair. And actually, this question, can anybody that can answer it, please do. You know, I'm really scrutinizing the bill, looking at it line for line, and I'm seeing it as a disclosure, oversight, and reporting. Like, those are the things that I see that are made mandatory in this bill. Where are you finding anything in here that says that would put a company out of business or would disallow telematics to be used? I'm looking to try to track with you to see.
I will take that first question. Page 3, see where they're putting in some brackets. That was legislation that was passed, I think, in 2018 that would permit a company that only offers telematics to able to operate, that say that if I only offer telematics and you choose not to enroll in telematics, I can't offer you a premium. And that's on, let me find the exact line, I apologize.
You're talking about that section of language that was deleted?
Yeah, they have this, hold on a second, I've got to get my bill out, I apologize. If somebody else sees it on the page.
So it's on page 3 at the bottom, 1, under 27-501.
Unless the insurer?
Unless the insurer only offers private, blah, blah, blah.
And then all of that is taken out.
On the next page.
All that's taken out, and that would actually say that if a company only offers telematics, they couldn't operate in the state.
I'll look at that some more. I guess I'm not reading it like that, but, you know, we can.
Yes, because what it's saying is a company may not, an insured may not require an insured to operate in, to take telematics. But if you're a company that only offers telematics, they had to make an exception and say, if you only offer telematics and when you're trying to get a price with that company and you say, I don't want out telematics, then they can't offer a premium. You'd have to go to another insurer. They can't, that's all they offer. So this is in the initial application stage.
Well,
so they're saying unless the insurer.
I guess I don't read it that way. I'm seeing in T, it says with respect to private passenger motor vehicle insurance, an insurer may not, and then there's number 1 that says require an applicant or policyholder to participate in a program that measures. So that's saying that you can't make me opt in, right?
Unless.
So that's 1.
Okay, then you go down to line 32, which says unless an insurer only offers usage-based insurance. So that's the exception that's been put in for insurance companies that only offer telematics. And by putting those brackets, by removing that language, those companies would not be able to offer, a company that only offers telematics could not continue to operate.
Because you're automatically required to do so, is what you're saying.
Yeah, exactly.
Okay, I get that. All right. Okay. Thank you, and I guess there was one question or kind of comment I had about, you know, the rates being increased. I think right now, I'm accustomed to seeing my rates increase or decrease or whatever they're going to do after 6 months or so. So I'm not sure that it's fair to say that, you know, policyholders will see an increase that they weren't expecting, or, you know, might be out of their affordability. But they may not be able to afford this increase because that's the way we operate kind of now. And the way telematics works, and correct me if I'm wrong, you can see a change monthly, potentially, right? You could go up.
That would only be if you're signed up in a company that offers monthly, month-to-month premium stages. I know that's a minority, that companies that operate on a month-to-month, you know, this is the way you drive, and this is what your premium will be after 30 days because you were a bad driver, or you could see a decrease because you've actually improved your driving skills. So that would be on those few companies that bill month to month and give you real-time feedback and say every 30 days, we're going to give you a different premium based on your driving history. That's not the majority of companies, that's a minority of companies.
And in Maryland, how many telematics-only companies are there?
I only am aware in my group of 2, but there could be, I understand that there are some, like, there could be, you've heard this before, that, let's say, I don't know, just name a company. And within that company, they could have 5 or 6 companies under that umbrella. One of those companies could be a company that only offers telematics. They have other companies within that umbrella that offers the other type of insurance. But that would put that particular company out of business.
Thank you.
Can I respond to your comment about the cost of insurance over the course of the policy?
Yes, briefly, please.
I think, I don't, like Nancy said, I don't know that many companies do this where they do make rate changes throughout the course of the policy. But right now, Maryland law would permit a company to increase someone's premium in the middle of their policy term, like before 6 months, if you give them a 45-day notice, give the consumer a 45-day notice, and the notice has to require certain things and all that kind of thing. The bill would make it so that the companies would not have the option of providing 45-day notice and then giving an increase. So the only time to give an increase would be 6 months or longer. And if you have someone who signed up for telematics and they may think that they're a good driver, so they may be expecting discounts, but they're going to be getting increases, for example, it might be to their benefit to receive periodic increases over the course of that 6-month policy, so that at the end they may decide they don't want to be in a telematics policy going forward. But they don't have that information at the end of the 6-month period. Do you know what I'm saying? Until it's time to pay the increased premium all in one go, if that's what the outcome of the telematics shows. I hope that clarifies. I'm not sure if I've made it worse.
Yeah, sort of. I mean,
Sort of worse.
yeah. Thank you.
Okay. Any further questions, Delegate Taylor? Okay. Delegate Conway?
Thank you, Chair. Thank you again, panel, for coming in. So is the consumer made aware that this data may be sold?
I know that there's disclosures in the beginning telling them about the telematics program. I don't know if that's part of the disclosure. There's also, in order for them to, when you go to sign up for telematics, there's a whole disclosure about what this is going to do, that it's going to be tracking your driving. There's also, you have to provide the carrier the right to track you when you're driving. So there's a whole privacy section where they have to say, I permit you to track me using either my phone or the device that's in the car. Yes, hi.
The key word I said was sold. What I want to know is the consumer made aware that their data may be sold. That's what I want to know.
I would have to check that for you. And as I said, I know the data is aggregated, but whether or not they inform the consumer, I do not know.
I don't care whether the data is aggregated. I just want to know if it's going to be sold. So
Okay, I will find out for you. Thank you.
Thank you.
Delegate Woods?
Thank you, Madam Chair. So a couple of things that everyone talked to you offline, because not only I was asked about using telematics, and I said no. And not only did my insurance increase, it increased highly. So I wanted to know, first of all, I have 2 questions. First of all, is there any documentation that says they cannot increase your insurance if you decide you do not want to use telematics? Number 1, I want to know if there's something in writing. Number 2, I wanted to make sure I was hearing clearly. I heard the sponsor indicate that because there's no oversight, you don't know what you can object to. You don't know what you can question. But I thought I heard you say that you do know specifically what you object to And so I just wanted to clarify, is all of that in real time, and how do you get that information?
I can't speak for every single company out there, obviously, because I only represent part of the trades. But anyway, when you download the application on your phone, they give you feedback. I think Delegate Cardin talked about that. They give you feedback, and they say, this is today's journey, this trip, we've recorded this on your trip. Now, those apps have a section where you can dispute. Or if your carrier, you don't have that that section on your app, you can also call the company and they will make that change for you, saying, hey, this says that whatever, I was talking on my phone. And in reality, you gave your cell phone in the back seat to one of your kids, and they were talking on the phone while you were driving and the app was running. You can call the company and say, that wasn't us, that was my son, and I apologize, but the phone was in the back seat and not, look who's here, and whatever. So there is a means to do it. They're asking about a specific appeals process, and we're unclear because there's already a very large consumer complaint section at the MIA that you can call in, file a complaint with the MIA. It's right on their website, and they advertise about it a lot. So what's the difference between the regular complaint process versus an appeals? We're not sure. We just ask that as long as we have some sort of process that every company should have a process to dispute that information. We agreed to that, and you'll see that I had some amendment language in there about that.
And to the first question, are you aware of any documentation that assures that your insurance does not increase because you deny telematics?
I would like to get some more information because I feel like that would be a complaint. I mean, they may be saying and I apologize, I know this is taking longer than you expected. You go to apply and they have two sets of pricing. One would be if you choose telematics or if you choose not telematics, if they offer two products and you decide at application time that I'm not going to take the telematics product and they're offering your other rate, then I think that could happen. But whether or not they could raise your rate because that just seems like that's not correct.
So this was not a new agreement. I've had this insurance company for years.
Yeah.
When they offered the telematics and I denied it, and literally my insurance went up exponentially.
And it did happen the minute you declined it?
It was at the renewal of my policy.
Okay, so maybe so that, I think we need to look into that further because I
definitely want to have that conversation.
I don't know if it was just a large general rate increase anyway, and that was an offer to lower your premium or not, but I think the MIA would like to look at that because that is concerning. And you know, my past history as an insurance agent, that just raises concerns for me, so.
All right, I definitely want to have a conversation. Thank you, Madam Chair.
Thank you.
Great. Delegate Embry.
Thank you, Madam Chair. So I just want to return to this point about what can be done with the data. And if I understood what you said, it was that if it is sold or shared, it is disaggregated. Is that your position?
Yes.
So I've been reading, just because it's been a long hearing, lawsuits, class action lawsuits, as well as enforcement actions against Allstate. I'm sure there are others. I'm not picking on Allstate. But the specific allegations is that Allstate and the subsidiary it used to collect the telematics, they were selling consumer profiles, not disaggregated, information about the consumer based on, everything we've talked about, to other insurance companies so that it could be used to assess how they should be insured. So I know these are lawsuits, but they're multiple and states that have brought these actions. So I just want to be crystal clear and ask this question very clearly. Is there anything in Maryland law that limits or prohibits either the insurance company, if they're doing it directly, or a third party that they're using from selling or sharing that data in any form?
I would need to find out that specific question. Thank you. And like I said, I wanted to find out about third-party vendors, and I can find out about that as well.
Thank you.
I would assume that's a real privacy issue, so thank you.
Thank you.
Yeah, Judiciary didn't have insurance before now. But we have it. And no, it's not even the questions. I don't say that just because of questions. I say that because while I know telematics has been around for a long time, there's a huge amount of information that is obtained, and it is concerning, that level of information. It seems that that could possibly be tailored down quite a bit. Seems like it was experimental to find out what really was needed, but now that we can, and hopefully there's been some data that will tell the insurance companies what they actually need, and we can start to pare it down quite a bit. It's a little concerning. With that said, though, I will, and Subcommittee Chair for Insurance, Delegate Taylor, and I would love to, and I started doing a little dig on the history on what Maryland did, how we even started and all of that. So if you have any history and that you can provide to us on how telematics even came, how we passed the bill to allow this much information, et cetera, because I'd love to hear I'd love to look at the testimony, all of that, and I will do that. I will do that if I have that information. So the Vice Chair.
Thank you, Madam Chair. So you are against any guardrails for the use of telematics by the insurance companies? Is that true?
No.
Okay. So what additional guardrails are you for?
Well, I feel like that we already are regulated by the Maryland Insurance Administration. When it has in there the Insurance Administration shall draft these regulations, they already have authority to draft regulations about telematics. They just issued a bulletin about our notice of premium increase. We are required at renewal, whether it's telematics or it's not telematics, 45 days in advance. If it's a rate increase of 15% or greater, we need to say specifically why the rates went up.
Thank you. But you do realize that there have been a lot of unknowns here today.
Yes, I understand that.
A lot of unknowns, and if you don't know them, I mean, I'm sure the insureds don't know them. So this is what I do for a living, and I will tell you that I have been in situations where my clients have got into car accidents, and the insurance company beats us to the car lot to pull the thing, that little telematics machine, from the car and take it. And there was nothing by law that I could do to stop them from taking it. And that actually happened. So we need guardrails. Whose property is it? We just need guardrails. So please appreciate that that was a really important time for me, because as a lawyer, I'm thinking there ought to be a law. And there wasn't.
And I think on a national level, we're also having that same problem with automatic vehicles. Like, who owns the data? Do you own it? Because if an autonomous vehicle gets in an accident, we're not allowed to have access to the data, so.
All righty, members, we are excited about this new topic in our committee. Delegate Simpson.
Yeah, so obviously the intention of the bill is to put some guardrails on there to protect people's privacy, and also to make sure that you fully understand what you're opting in and what can be done. And there are a lot of questions that have been asked specifically, and you say, well, they can't do this or they can do that, or, well, it's just aggregate. So I'm interested in, and it hasn't directly been asked, but when you're providing information back to us, I really would like to see what are these laws specifically that you're saying that does have some guardrails on it. You're saying, well, I could just call the company and say, my child was using my phone in the back. Well, what if I don't know, I'm not paying attention necessarily or aware. If you're pretty sure that somebody has to opt in, I would love for you to send us that language and that confirmation that someone is actually opting into that, and what the law is or the regulation that's based on. Or is that, as our vice chair is saying, might be something one company is opting, whereas others, it's not a requirement. Is it a requirement that they are opting in to allow their car?
Yes, it is a requirement that you have to opt in.
Well, can you send us that regulation or that law that specifically says that you have to opt in, what that language is, and what it says that it can be used for? I'd like more information about, is this something that, a feature that they created and it's just not regulated yet and they're using it whichever way they want that they see fit? I know a new car we just bought, what is it, regulate like if you're, between the lines and that kind of stuff, tells you to go get coffee, we would like to know.
Sure, and as I mentioned, we didn't have any information. We're not opposed to disclosures. That is not in our testimony that we're opposed to any disclosures and that the MIA drafts. That's not at all. And we're not opposed to us offering a process to dispute any of the information. It's just that the word appeals, when we feel like there's already a complaint unit there, we're not opposed to that in any way. It's just that some of the language is something that the MIA can already do. They already have the right to draft regulations. They can already require a company to set up a governance program.
But the regulations are based on what laws that are written.
But I'm saying,
hold on.
Yeah,
So regulations are based on what laws are written. If there's no laws that are written, just like, Delegate Wood said, if she's opting out, if there's no law that restricts them from upping her insurance for opting out, they may be in a gray area. There's going to be no regulations on that because there's not a law. Regulations are based on, so it's where an agency is creating clarification of a law where there's that gray area. If there's no law, then they're not creating that. So these agencies may actually be doing their own thing based on something that's just been created and kind of a gray area.
Well, I think you misunderstand. I'm not saying that the MIA can't draft regulations about telematics. We're not saying that. We say they already.
Say that you did. I'm saying.
No, I said they already have the authority to do it. I'm just saying that the way that it's drafted in the bill, it's so specific in the way it is drafted that it almost requires them to do certain things in the regulation. It uses the word shall, and it has a prescriptive section about those regulations. I am saying that the MIA has the ability to draft these regulations, and we would be happy for them to draft the regulations, but I feel like that they need to do it in specific ways that they see fit and not require them just to address certain areas without them doing an oversight and say, I don't think we need a regulation here. The way it's drafted, they're saying they have to draft it. I said the word should be may draft regulations, and they have the authority. We're not disagreeing that they can't regulate telematics.
Well, any laws that you are already aware of that are structured about, or the regulations regarding what they can do with this information, or the opting in and the opting out, I would greatly appreciate. So
sure, and I specifically want to look at the issue about third-party vendors and the data collected. So I definitely, I'm curious myself. So, and when Delegate Davis said the story about one of her cases, I'm interested in that just because I was fighting this bill down in Virginia. So the whole thing about discovery and telematics, I'm interested as well. So thank you.
Madam Chair, thank you for this work group.
Well, Ms. Packman has been patiently waiting. So if you could be the last word on the bill. Thank you.
Thank you so much. Oh, good. I just wanted to make sure I was unmuted. I wanted to address 3 issues. Number one, getting back to Delegate Woods, I think it was, and her question regarding her being offered the telematics option and not taking it and then receiving a premium increase, and her understanding that those 2 things may have been connected. I'm wondering if it's possible that the carrier saw that your premiums were going to increase substantially, basically regardless, and suggested a telematics program as a way of bringing the premiums down. The premium increase you experienced then might have been inevitable. It might have happened either way, if that makes any sense. And I think this was in response to something Delegate Simpson said. I can't speak for other carriers, but for Allstate, we have multiple avenues that consumers can use to dispute data that comes in through their telematics portal. So there's a bunch of different ways, and some of them I think require lower level escalation before you get to higher level escalation, but there's numerous avenues for them to pursue in that regard. And finally, I've of course just wanted to touch on the mention of lawsuits involving Allstate. I'm aware of those. They are as far as I know, they're all pending in other states, and I don't believe any of them have even been considered on the merits. So I just want to avoid us trying to draw broad generalizations from basically what amounts to just someone file a lawsuit and, we're still waiting to find out what the actual facts are. Thank you.
Thank you. Thank you. Yeah, because I think what has been evident here today is that obviously the committee has an interest, and I'm glad we were able to ask our questions, but we need to move on to some of our other bills now. So thank you so much.
Thank you.
No, thank you, and I'm available as obviously, and we'll try and get as much information for you as possible.
Thank you very much.
Thank you.
So that concludes our bill hearing for Senate Bill 351. We're going to move now. First, I need to ask, is there someone here from Senators James and or Reedy's? Okay, great. So just hold on a second. But is there a staff member? Are you this? Okay, great. All righty. So we're going to finish up with Senator Washington. We're going to hear Senate Bill 865, and then we'll go to, I got Senator McKay. Everyone's a delegate today. No, I'm just joking. Okay. Yes, Senator Washington, Senate Bill 865, please.
Do I have a panel, Madam?
No, I have it indicated that that you're sponsor only.
Oh, okay, perfect.
Okay.
It's all good. I want to just say welcome to finance and insurance industry. That's what we do within finance. We see a lot of this stuff.
I apologize. I apologize. We have a little bit of an interference here. So I actually have an indication that Marceline White, yes, and Jamie Sexton are also testifying with you.
Thank you.
All righty.
Ma'am, so this is your house. I'm just here.
I'm sorry?
This is your house. I'm just here. All right.
Well, thank you, and please continue.
Thank you, Madam Chair. For the record, Senator Alonzo Washington here to present on Senate Bill 865, which I think is a really great bill that should not take us 2 hours to discuss, but should be able to help us in driving down premiums, in which we spoke about before, for consumers here in Maryland. I mean, that's what we're here for, and that's why the affordability of private passenger automobile insurance, that work group needs an extension. And the reason it needs an extension is because they made some great recommendations, but they kicked the can down the road on significant cost savings and affordability for consumers here in the auto industry sector. And so I'm asking for this committee to approve this bill, because what we need to do is for it to be, for the work group to be just a little bit more balanced, and to add, since Judiciary is new to insurance, now we're adding someone from Judiciary. Hopefully they really are excited about insurance. And to ensure that we have folks from both sides of the issue on this to balance it. I worked this bill out in the Senate so that, not only MIA supporting the bill as it was introduced, but now bringing on board the auto insurance industry that told me if I was to add 2 additional people to this board, that they would be okay with this bill moving forward. If they come up here and tell you anything else, that is not truthful. I've been told that by the industry themselves. They walked up to me and reassured me that they wouldn't be in opposition of this extension. And part of the reason for this bill is to ensure that we're looking at this geographical destination for these rate settings. Right now, insurance companies use zip codes to quantify what your rate is going to be. No matter if you live on one side of the road or the other side of the road, if you live on one zip code and really cross the street to another zip code, your insurance premium can increase or decrease depending on where you are. Under the study, under the work group, they did an extensive conversations about it, but they said, well, we'll take that up later on, so we'll consider that. Under this bill, what we're asking for is them to continue that conversation and many other conversations to come up with concrete recommendations so we can have a piece of legislation in front of us, or not, that show that we want to drive down costs for consumers here in the state of Maryland. Insurance premiums are the highest in the country here in Maryland. Let me say it again. Insurance premiums for auto insurance is the highest in the country here in the state of Maryland. I'm asking this work group to go back to work and drive down costs for consumers in Maryland. Thank you, Madam Chair.
Thank you. So just to make sure I understand, this bill is actually not super complicated. It is merely an extension of the termination date, right?
And it adds four members.
2 more members.
Adds four
Okay.
members to the board.
Adds more members, but it's not the same as it was before members. I just want to make sure everybody understands that. Okay, either Ms. White or Ms. Sexton, whoever's ready.
Good afternoon, Madam Chair, Vice Chair, members of the committee. For the record, Marceline White, Executive Director of Economic Action Maryland Fund, here in strong support of Senate Bill 865. I was honored to serve on the work group last year, representing the consumer protection perspective, and of course would be honored to serve again. I want to just underscore that last year the work group's recommendations were to study how to create a low-cost auto insurance program in Maryland and to look at the use of territorial ratings, zip codes, that contribute to disparate impacts on insurance rates. This bill will allow the work group to continue to discuss these things and to be able to come to the General Assembly in a year with potential recommendations for this body to consider in terms of auto insurance affordability. We support adding additional consumer protection perspectives and other perspectives for a more robust conversation. And I want to say that I don't think we can afford to wait. We did a survey of 550 Marylanders this January, and 74% saw a price increase in their auto insurance in the past 12 months. 13.5% said they can't afford the price increase in their auto insurance and cannot afford to pay it. And 55% said they are going to struggle to be able to afford this increase. So we do need to address the affordability crisis we're in auto insurance, and this will allow a balanced consideration of these issues to come together with a work product at the end of this year for you all to consider. So for all of these reasons, I urge a favorable report.
Thank you. Ms. Sexton.
Thank you, Madam Chair. For the record, my name is Jamie Sexton. I'm here again on behalf of the Maryland Insurance Administration to convey our support for Senate Bill 865. As the committee is aware, this bill extends and adds to the duties of the work group on the affordability of private passenger automobile insurance, which the legislature established last year and which produced a report that we've discussed many times here today. That was released late last year. Specifically, it requires that the work group develop concrete legislative recommendations to reduce premiums in Maryland, including specific recommendations regarding the use of territorial rating and other rating factors that may contribute to disparate impacts. Every state currently uses some form of territorial rating, but there's some variation from state to state on how they implement it. This bill allows the work group to look at how Maryland currently uses territorial rating, how that compares to what other states are doing, and if there are any recommended changes that could or should be made based on best practices from other states. Many of you have probably heard Commissioner Grant state that the MIA is first and foremost a consumer protection agency, and ensuring fairness in the processes that private passenger automobile insurers are using to establish premium rates for Maryland drivers perfectly aligns with that charge. For these reasons, we request a favorable report. Thank you.
Thank you. Members, do we have any questions? Delegate McComas?
Madam Chair, I don't know that much about insurance, but I do agree. I don't like paying insurance, but I have insurance. My question is, Maryland is a very, very small state, and it has a lot of kind of country roads, and then it has a lot of, suburbs that are very crowded. 95 is crazy. You know, you try to figure out when I should drive on 95 so you don't get the rush hour coming and going. My concern is that, is there any part of the issue with the insurance looking at the fact of the way the population density, the fact that we don't have, you know, we're not like Colorado or Wyoming where we're a nice square state and everything's, you know, you got elbow room. And I guess my concern is that there's some structural things I would say that also drive up the price rather than just the zip codes. And because I think, and I don't know if you guys have documented where are the major accidents are, or if they're just everywhere. I don't know. I honestly don't know. But I just think that we sort of need to look at what we're dealing with and then figure out how to get there. At least that's part of it. I mean, I realize that there probably is, you know, obviously if you go grocery shopping, you're probably going to pay more in Baltimore City than you are, let's say, in you know, in let's say Western Maryland or something, because you know they've got the farms and the farmers markets and stuff. So anyway, I just wondered if that's something that you think ought to be looked at with this. I mean, it's sort of like spreading it out a little bit, but I do think just from somebody that doesn't necessarily like driving on the interstate and everything, and have a great respect for, you know, how crowded things are, and particularly when you've got, you know, kids getting out of school and buses, and then the drivers are nuts. I mean, they really are. They're very aggressive driving around here. So anyway.
Yes, ma'am. Delegate, I think that's a phenomenal question and a phenomenal point. There are a variety of factors that go into how premiums are determined for any individual Marylander. And territorial rating is one factor in a plethora of them. And I think the great thing about this work group is it's not just looking at one factor in isolation. And do I think that there are lessons that can be learned on how other states use that one factor? Absolutely, and that's exactly what this work group will be looking at, but it won't be looking at it in a vacuum. And I think that's the wonderful thing about doing this through the use of a work group, is that there are a variety of voices at the table and a variety of perspectives being taken into account, and a variety of folks that are keeping us accountable and ensuring that no one factor is being looked at in isolation, and ensuring that it's being looked at holistically. Yes, ma'am.
Thank you. Members, do we have Delegate Taylor?
Thank you, Madam Chair. I have a really quick question. Which of the representatives that have been added to the work group were the recommendations of the commercial insurance companies?
I think it was actually, yeah, here it is. One representative of the National Association of Mutual Insurance Companies and one actuary who was the member of American Academy of Actuaries. And then the ones that we all agreed that we added before that was the two representatives of a nonprofit research or consumer advocacy organization with demonstrated expertise in automobile insurance rating practices and affordability.
Thank you.
You're welcome.
Any other questions, members? All right. Seeing none, thank you very much.
Thank you.
That concludes this panel and the bill hearing for Senate Bill 865.
Thank you all very much.
Thank you. We're going to move to Senator McKay. And Senator McKay, you have two bills.
Yes, ma'am.
Senate, okay, we'll start with whichever one you want to start with. I believe they're both going to be sponsor only, so.
They are, yes, ma'am.
Yep, so whichever one you want to start with is fine.
Certainly, if we may, Madam Chair, we'll start with Senate Bill 689. Committee, you did hear the cross-file for 689 already. Delegate Terry Baker. To remind you, the intention was the goal of Breeze Law was to establish a more structured transition period for violent and gang-associated inmates upon release, and the bill would integrate their parole requirements and crucial benefit programs already available, mandatory for high-risk parolees. We were, during the committee, able to find out in 2024 a great piece of legislation that was passed that actually was addressing the concerns and what we needed to address. And so the Senate, JPR, did pass out Senate Bill 689 with some amendments, and that amendments are as follow. renaming the bill as the Task Force for Creation and Division of Returning Citizens and Expanded Reentry Services Requirement, Authorization, and Extension of Report Deadline, Breeze Law. This was within Chapter 936 in the Acts of General Assembly in 2024. Like I said, it did just add a provision to add study programs and services to prevent recidivism of individuals in the state after being released from incarceration. It did extend the task force by 2 months. It was October 2026 to given its report. It's now December 31st to give those reports. Other than those two amendments, requests a favorable report from Judiciary. I am sponsor only, but I would like to remind you, behind me is Bree's family who have come down. They knew that it was only going to be sponsor only, but it was important for them to come see you again. And with that, I'd ask your committee to consider, as amended, Senate Bill 689 and look forward to any questions you may have, Madam Chair.
Thank you, Senator. Members, do we have any questions? All right, seeing none, that concludes our bill hearing for Senate Bill 689. We're going to move now to Senate Bill 483. Also, Senator McKay and Senator, whenever you are ready, sponsor only. Thank you.
Madam Chair. It's a pleasure, Senator Mike McKay, to present Senate Bill 483. This committee has heard this bill. The cross is House Bill 360. Just to remind everyone that this is the Clean Slate Act of 2026. It did require on or before July 1st, 2028, Public Safety and Correctional Services, the Judiciary to automate the expungement process of cases where charges are eligible for expungement. We did pass it out of the JPR and the Senate with a couple technical amendments. The main issue is sealing instead of expungement. Be glad to go over some of those amendments. I do believe you all have them, but you may have not had the time to look at them, and be willing to answer any questions that you may have to try to make this a better bill. We've been trying with the good Delegate Moon for a couple years now, and believe that this is the year. We think we're at where we need to be. So with that, I'm all yours.
Thank you, Senator. So I just want to, for the record, I just want to make sure that we correct, instead of sealing, we're actually shielding, right?
Correct.
Okay.
Yes, ma'am.
Okay, just wanted to be
That is correct.
clear on that. All righty, so members, we heard the bill before, but we hadn't heard it with the amendments. Do we have any questions? All right. Seeing none, thank you very much, Senator.
Thank you, Madam Chair. Thank
All right.
you, committee.
We are going to now move on to Senator James and Reedy's bill. And, oh, there you are. Okay, great. Did we lose? Yeah, I think Debbie stepped out. Okay, and actually, you think she stepped out? You've been waiting patiently all this time. I think, yep, they're calling her in now. You can come on in. Yep, you can come on and have a seat. Yep. Thank you so much. Thank you for your patience. Of course. And Ms. Feinstein, you know how Murphy's Law works. You've been sitting here all this time. So we're going to hear Senate Bill 465, and for the presentation of the bill will be a member of Senator James's staff, and we'll have Debbie Feinstein. Please begin whenever you're ready, and thank you for being here.
Of course, thank you so much. So good afternoon, Chair Bartlett, Vice Chair Davis, and members of the committee. For the record, my name is Maggie Delaney, staffer for Senator Mary Delaney James, here to present Senate Bill 465, Criminal Procedure, Admission of Out-of-Court Statements in the Second Degree. Senate Bill 465 adds second-degree assault to the statute that allows prosecutors to introduce statements in a criminal trial when the witness is unavailable and when that unavailability was caused by the wrongdoing of a criminal defendant. While not listed as a cross-file, this bill is identical to Delegate Embry's House Bill 477, which passed unanimously both in this committee and on the House floor. With that, happy to take any questions or defer to Ms. Debbie Feinstein, who's been a trooper today. Thank you so much, and I ask for a favorable report.
Ms. Feinstein, do you want to add anything?
No, actually.
Okay,
Thank
works
you.
for me.
Thank you.
Works for me.
You already passed it.
We already passed it.
I appreciate the opportunity. You already passed it.
All right.
And would ask you to do so again.
Thank you so much.
Thank
And
you.
again, thank you for your patience. I didn't recognize your face, and I apologize for that.
No worries.
Okay.
It's a long day.
So that concludes this.
Thank you so much.
Sorry, members, do you have any questions? All right. Seeing none, that concludes this panel.
Chair.
We're going to move to our unfavorable panel with Chastity Simpson, if you're still here. She's virtual. Okay, is she available? She's available? Okay, great. Ms. Simpson, whenever you're ready, please.
Hi, good afternoon. Thank you. Sorry, I was having some technical difficulties. Good afternoon, members of the committee. I'm Chastity Simpson. I'm with the Office of the Public Defender. And for the record, I'm the District Public Defender on the Lower Eastern Shore of Maryland. We are requesting an unfavorable report on Senate Bill 465. The primary issue that we take, I would say, with this bill is that it's etching away at the confrontation clause, which is one of the most important things that we have in our Constitution to protect those who are accused. I noticed in some previous amendments to this particular statute, 10901 of the Criminal Courts and Judicial Proceedings article, that about 6 years ago, the statute was amended to lower the standard of proof that must be shown of wrongdoing to the lowest standard in our system. Rather than clear and convincing evidence, we now need only a preponderance of evidence. This is now seeking to expand the universe of crimes to which this can apply to include second-degree assault, a misdemeanor in our state. It's one of the most widely charged crimes in our state, often charged through commissioner complaints, where someone can literally go to a commissioner's office, write a written complaint about an incident that occurred, and have someone charged with the crime of second-degree assault. The confrontation clause is what we use to test that statements that are made when someone is upset. Someone may have other motivations for filing those charges to seek a specific outcome. And it is through the confrontation clause that we test that in a court of law. The notion, it's been said at previous hearings that defendants are somehow aware of this and utilizing it to their advantage. It's not been my experience that many defendants are intimately familiar with the laws of evidence or how that works. And I believe that we have sufficient ways to address witness intimidation through the system as it currently exists. There are charges that can be filed against someone for intimidating a witness and encouraging them not to come to court. There are ways to have a witness attend court even if they do not wish to be there, and ways to introduce their statements while they are present in court, even if they do not wish to say that again in court. But those systems allow those statements to be challenged, allow them to be challenged by cross-examination, an essential element to our system that helps us ferret out a patently false allegation from a true one. Without a witness there, that's really just not possible, and we are accepting statements that are made outside of court to secure convictions, and that is not reliable. And that's why we have the confrontation clause. That's why we honor it the way that we do. So we would ask for an unfavorable report on this bill.
Thank you. Members, do we have any questions? All right, seeing none. Thank you, Ms. Simpson.
Thank you.
All right, that concludes our panel and our bill hearing for Senate Bill 465. We're going to move on now. Everything else from here on out is going to be sponsor only, I promise. And if anyone is here to testify on any bills, I don't have any indication that you are to testify. So Let's move on now. We have two senators who have been going in and out, and I appreciate your patience. Senator Muse, if you don't mind, I'm gonna call Senator Folden up first, simply because he has one bill. So Senator Folden, if you would be so kind to present Senate Bill, you have won the lottery. Senate Bill 202, and I understand, members, we did hear this bill, and it has been amended, so. Yep, we did hear this bill. It has been amended. So, Senator, whenever you're ready, please begin. Thank you.
Well, Madam Chair, Vice Chair, esteemed members of Judiciary, it's good to, well, let me just say I'm back. I don't know if it's good yet. We'll see how the questions go. Y'all take it easy on me. So before you today is Senate Bill 202. Regarding police discipline in order to show cause, the purpose of the bill is that it would authorize a police officer who is denied by certain rights to apply to the circuit court at a certain time for an order that directs the law enforcement agency to show cause why the right should not be granted. And this is not relating to matters that go to the ACC or the Police Accountability Board. These are more or less matters where you have secondary employment, where you have whistleblowers who are trying to say something and then they're facing punishment from above, like loss of certain privileges. And this would allow us to have a process in place that would provide for them a hearing to expedite the show cause of why they should be allowed or still continue to be suspended from certain provisions on things that are not a matter of police discipline with the Police Accountability Board or the ACC. So, and also there is one amendment that was on line 18 after the subtitle that insert that the trial board lacks jurisdiction to adjudicate. Again, showing that it doesn't deal with any disciplinary processes that fall within the purview of the ACC or the Police Accountability Board, but more or less gives officers some type of recourse in the event that there is an action taken against them in a manner that would be questionable and that they would be allowed to have their day in court, so to speak. So with that, I would request your favorable report on Senate Bill 202. I'm happy to take any questions.
Thank you, Senator. Okay, so let's go back to that last amendment you spoke of.
Yes.
So I'm assuming that's on page 2. You said line 18.
It was on page, mine says, no, it's on page 1, line 18.
Okay.
I apologize.
All right. Well, let's see. And you said that
it's on the reprint.
Mm-hmm. Yeah. Oh, maybe that's what it is. Yeah, that's what I couldn't tell. Is this a new amendment that you're offering, that one?
No, I believe this is as it was moved over.
Oh, okay. So we don't, it doesn't look like this. Oh, right. Okay, so did the Senate adopt the
Yes.
new, line 18? Okay.
Yes.
All right, so I'm looking.
So it's in the third, it should be in the third.
Yeah, so we should be able to see it in the third reader version of the bill, reprint of the bill, or at
It
least.
should be in the reprint as well, Madam Chair.
Yeah, I kind of don't see it in the reprint, but that's okay.
Okay.
Oh, you know why? I know why I don't see it.
You're in the House version?
Nope. I'm not going to tell you what I was doing wrong. That's between me and the computer.
Yes,
All
ma'am.
right, so with that said, still not getting me what I need to see. That's okay. Yep. Yeah, I can't see what you are referring to, and I see you don't have your computer.
Yeah, I have it here.
And even though I said this was sponsor only, but if somebody can clarify, Mr. Plout, can you clarify?
It's this, that's what she's trying to clarify. That was accepted, right?
Let the trial relax jurisdiction to adjudicate. Yeah, so, this is, so, hold on. Ours had a
Hold on, don't
different,
get,
ours had different.
hold on, no, don't. Could you, Charlotte, can you turn on his mic? Mr. Plout, thank you. Yeah, because if he turns it on,
I thought it was,
could you?
hold on, I just
You
had
can see it?
here.
Can you see it?
This is what I thought it said.
Okay, is there a line 18
This
on
in
page?
310,
Yeah,
yeah, but it said,
okay,
but it said section, not
Okay.
subtitle. This is the
okay.
only difference.
So what we're going to do is give you a copy of what we see.
Okay.
And then maybe you can tell us what it is.
I'll do my best.
Because it's just not clear, and
Sure.
this is our opportunity to ask you lots and lots of questions.
No, I
so.
appreciate that. And especially because I'm in front of Senator Muse, so I'm just
Oh,
thrilled.
that's right. I don't want to hold you too long then. All right.
That's my good seatmate, Madam Chair. We're good. He said, take all the time y'all need.
Okay. Okay, so council is giving you a copy of the third reader.
What the Senate adopted with everything.
Thank you.
This one
Ah, so,
So this is what they adopted. I must have misread in this part. I misread in this part, I'm guessing, which was. Okay, so, Madam Chair, I stand corrected that the current version that you have with that amendment is the amendment that was adopted. My apologies.
I'm sorry, say that again.
So the one that you just provided me with that language change is the one that was adopted. I knew the one was adopted. I just
Okay,
looked at
gotcha.
the wrong amendment. I
Okay, so I
apologize.
just want to make sure,
Yes,
okay.
ma'am.
So what you read about line 18, I can ignore?
Correct.
Okay, that's what I needed. That's what I needed. All righty. So members, do we have any questions on the bill as amended with the text that is provided under third reading? Okay, the vice chair.
Going to their questions.
Oh, I'm sorry. Oh, you were, okay. Do you have any questions?
Go first, please.
Okay, sure. Delegate Embry.
Thank you. I wonder if you could walk me through how this would work. I mean, what would not be available?
Okay, so here's what I want to do. This was intended to be a sponsor only.
Right.
And so I only wanted, the reason why I asked for a little bit of clarification was because of the amendment that you provided. So could we keep it as sponsor only? Because if we don't, it would have to open up the whole hearing.
Okay.
All right, and that's not quite where we were planning for today. So if we could just keep it sponsor only. Thank you. Okay, Delegate Embry.
Thank you. Or if I could give a hypothetical, just to walk through
Sure.
how this would change things. So let's say a police officer is in some way disciplined for what they believe to be protected First Amendment activity, but the department doesn't think so. They think they were in an
Sure.
official capacity. What would happen without the bill, and what would this bill change?
So right now, if they could be technically, I mean, because that's not that doesn't fall within the Police Accountability Board or the ACC's purview because they were off-duty conduct, they could be taking certain things away from them, whether it be secondary employment or the like. And this would just facilitate the opportunity that the agency has to show cause why they are continuing a disciplinary or this type of discipline, if you will, against the adverse action against the officer with no end in sight, because this isn't covered under the PAB and the ACC, so there would be really no end to it. It could be ongoing for an extended period of time without any type of definitive action.
But they could, under current law, they could argue that it's not fair internally. They could also file a lawsuit currently. Is that all true?
Can they? You can file for a writ of mandamus.
But they could also sue, right? That their constitutional rights are being violated. Sorry, I'm sorry.
So
Asking this
I know you're asking me and the guy that's got all the really good subject matter area, because
Okay.
he's got all the answers. So I will do my best to explain it in a manner that makes sense. But the practical application of this is that, so there is no indefinite time period that an adverse action is taken against an employee. And basically this bill is meant for, really good actors, because you'll have some whistleblowers or you'll have certain actions that they take where they bring to the forefront or to the executive staff's attention an issue, and then the executive staff may not want to hear that. And if they take an action against them, it could be indefinite, and they would have no recourse because it doesn't fall under the ACC or the PAB's purview.
What I'm trying to get at is they do have recourse outside of those options.
Outside of that, they could do yes.
Okay.
But thank you.
Thank you.
Delegate Valentine?
Thank you, Madam Chair, and thank you, Senator, for being here. And I want to ask you a couple of questions. One, because Delegate Cardin's not here, he asked me to ask, how is your bill specifically different from his? Were they weren't as a cross file? Was there anything that's specifically different that you can think of?
If they're not a cross, I don't know that did his come over? Did it leave out of committee?
No.
Yeah.
I just wanted to know if there was anything different that I should ask. With that being said, I'll start into my questions.
We get a lot of bills. You guys have like 2,500 bills in this chamber.
You kind of touched on it from Delegate Embry, and I'm concerned about the lasting forever. These individuals that I'm assuming suspended, they could be suspended or different assignments, and this just goes on for infinity. We're talking guys or gals that are 6 months, a year, and they have no idea why they're being suspended. Is that part of this?
So that could be part of it, but the idea is that there's adverse action being taken on an employee that doesn't fall within. This is kind of like a small area within when we did the police reform measures, that there was absence of like a fact-finding opportunity. There's no recourse to them except to go through the courts in a different manner and file suit. Whereas this shouldn't be something that should be able to be delayed. They should be able to go in front of a judge and have the case heard and request an injunction, if you will.
So one of the arguments I've been hearing about from the other side on this is this will create a backlog. This, to me, seems like it would actually speed the process up. Is that your assessment?
It absolutely speeds the process up, and it stops the agency, again, from continuing to furlough out these adverse actions because they can against said employee.
Okay, perfect. Thank you.
Thank you.
Any other? Okay, now that's kind of interesting because Delegate Phillips is not there, but his light is flashing. That's a little scary. Okay, hold on.
I think that was actually, I went up there, I was going to ask myself some questions to help myself out.
All right, that's interesting. All right, so are you ready with your question? Okay, Delegate Woods. There you are. Your light was flashing as if you had a question. Okay, Delegate Woods.
Chair, so I have a question with regard to the question that was asked by the League of Women Voters with regard to the MPAA 2021 and this being antithetical. Can you please respond to that?
With what, Delegate? I'm sorry.
The League of Women Voters said that SB 202 calls for a procedure that is antithetical to the process established in the Maryland Police Accountability Act of 2021. I was asking if you could speak to that.
Thank you, Delegate. Thank you for the question. So the League of Women Voters are bringing up a scenario that they're not seeing that this is absent within that current structure of the makeup of the police reform of 2021. There's a gap in it. That's what this bill is looking to do, is close that gap. I don't know that they fully understand the bill or the legislative intent, or maybe they don't understand the whole idea behind when you have now with the Police Accountability Board and the ACCs making these reviews, because those are for disciplinary type things where there's a complaint filed by a citizen or something lodged in that manner. This is something where there's an action taken that's adverse against an employee, has no contact with the public, it's not dealing with anything of the like, but it could have an adverse effect on them, whether it be suspended from secondary employment because they brought an issue forward or something of that nature. And this is really this bill is really to protect the good actors that are bringing measures forward to make policing better that may be attempted to be silenced through adverse actions that are outside the purview of the ACC.
So is that means that they're inaccurate when they say or that it's misrepresented when they said that the accused must go through the entire administrative process before appealing their decision to a court and cannot interrupt the process to complain to a court that one or more of their rights has been violated?
So in that action, and if I'm not mistaken, I'm going to ask to make sure, but there is no timeline given for them to do, for the handling of this. So they could just continue it on, this adverse action, without any justification to show cause why they should be able to continue this adverse action. Whereas under the ACC and the PAB, the Police Accountability Board, there's measures in place, there's timelines in place that have to be adhered to for these type of decisions to be rendered. On this one, there would be none because it doesn't go to the ACC. It's handled strictly in-house. There's nothing goes to the ACC.
Okay, I'll ask my remaining questions offline. Thank you, Madam Chair.
Thank you. Thank you, Delegate.
Okay, well, I can ask. Okay, so just want to clarify. So I'm looking on the reprint, just to let folks know, I'm looking at section 3-110 on page 2. And so what I see is that the officer cannot be discharged, et cetera, et cetera, et cetera. And it almost seems like they are either the whistleblower in the sense of disclosing information, or, well, actually whistleblower, because it says disclose information that evidences mismanagement, waste, danger to public health, violation of law. So those areas, so if a person is a whistleblower, you may not know the answer to this question, and it's okay if you don't, because I got to look it up myself. But aren't there already federal whistleblower protections that are available to all employees?
So with that, I would say that, yes, there are whistleblower protections that can be in place, but this is about the idea of the show cause of the adverse action that's happening against the aggrieved employee.
Oh, sorry. I understand now where I erred. And I'm not going to tell you that either.
Thank you. I got one early on. We're even.
All right. So essentially, when I look at the amended version, the only thing, and see, this is why I was confused. The only thing that is added is section E. Okay.
Yeah.
Section E, a police officer who is denied a right granted by this section is not eligible. Okay.
Correct.
Okay. And that right granted by that section is the whistleblower section?
Correct.
Okay. All right.
So it's actually, it's not promoting any police misconduct. It's promoting the idea that they can be safe to act and question and bring forward these issues without, at least if they get suspended or if they feel there's an aggrieved action, that they can then take it and have the agency show cause why it should continue.
Okay. So now any other state employee, now we're getting into the meat of it, and now it's starting to make a little bit more sense for me. So any other state employee who is a whistleblower, and if you don't know the answer, it's quite all right. What is the mechanism that any other state employee who is a whistleblower uses? Do they also go to, and mind you, I know other state employees don't have the trial board, et cetera, okay?
Sure.
So take that out, but are they able to go to the circuit court for an order that directs,
So there is a state process, or there is a process for state employees.
And so is that all internal? I mean, I guess what I'm asking is, would they ever go to a circuit court? I guess they could appeal any internal decisions.
Eventually.
Okay, I figured it out.
Eventually, it would go to the courts, yes.
Okay, figured it out. Thank you so much. Thanks for working with me.
No, thank you for working with me.
We work together. Okay. Vice Chair, I can call on Phillips. Delegate Phillips?
Okay, all right. So I want to kind of, and you, Madam Chair, you started going down this path. For something like this, there are different paths that an individual can take today. Is that fair?
For what, Delegate?
So if a person has, if it's a whistleblower today, and I know in this case, a police officer is a little unique scenario because there may be some retaliation from senior management.
Yes.
I'll use that term.
Correct.
In most instances, state jobs, municipal, et cetera, they're represented by unions.
Correct.
Couldn't they bring this to a union to make their complaint?
Yes.
Yeah, right.
So, yeah, they have a union, they have a FOP, but it doesn't, again, the problem with the current measures that was moved forward in 2021 is it doesn't create, it allows this to continue on to an extended period of time without them having to show cause why the actions are being taken against the employee.
But I'm saying, I mean, that's part of why they have bargaining agreements, et cetera, and there's a complaint process that the union could bring on behalf of the officer.
So that's yes and no, because not all police officers in the state are covered by their own separate union.
And without doing this legislation, an individual, if they thought they were harmed, could bring a civil case. They could actually just hire a lawyer and go into court.
Yeah, I mean, you could, but that, again, there's no provision for any expediency on this action. I mean,
and so this speeds up the process?
Yes.
Okay. And at no point would you see a conflict, because I think many people are concerned that at some point there would be the potential for a conflict from, everything we've done with PAB, with
Yes. Thank you for that, Delegate. So, look, the PAB has been in place. It's been in place for several years now, and it has a functioning process that deals with complaints against officers by the public, and it also entertains disciplinary measures that are brought forward for police misconduct from complaints inside the agency. And these measures can be heard. These measures are handled by the ACC, the disciplinary guidelines that are there, and so there's a process in place. This is outside that scope. This is something where, much like Delegate Embry was saying about, if someone is exercising their First Amendment right off duty and someone brings an action against them adversely and says, you know what, I heard you out, running your mouth the other day and you're not going to be able to work secondary employment anymore and until I change my mind. That type of thing. That's not okay. We don't want that. What we want is we want people in these positions of trust to be able to feel like they can then express these concerns, whether it's the mismanagement, the waste of resources, the violations of law or policy or improvements therein, that instead of having someone in these higher positions where they would take an action against them, that they would be able to, if there was an action taken against them for bringing these matters forward, that they would have a process to facilitate a much faster resolution to show cause why they're continuing to do that. That's all.
Okay. And so I want to be clear. This isn't that they don't have other options, but this is to expedite the process.
It's an expediency of the process, and it actually helps narrow down. It has nothing to do in conflict with the 2021 House Bill, I believe it was 674. It does not conflict with that.
Okay. All right. Thank you, Senator. Appreciate it.
So I'm in charge, so I get to ask myself questions.
Okay.
Ask questions, give myself permission.
If you're going to ask yourself questions, I'm out.
Give myself permission. Well, I really am going to be asking myself questions. But look, as a person who was here doing Police Accountability Board and 670, I remember how difficult it was to get rid of the LEOBR, Law Enforcement Bill of Rights. And the one thing that the Law Enforcement Bill of Rights did is that it gave police officers rights that normal citizens just did not have. So the idea that we're going to give you some rights, because this is what's happening, that normal people don't have, it alarms me. And I heard you just say something about you wore the wrong tie, and so now you don't get to work evenings anymore or something like that. Well, that happens in employment arrangements all over the place, and none of us get a show cause order. None of us get to run to the court right away and say, this happened to me, and so I need an immediate solution to it right now. So that is the core of my problem, is that we're going backwards instead of going forward. If there is another remedy that's necessary, that you need, and because I don't understand it, that you need in the employment sector, employment rights sector, or civil rights sector, or First Amendment sector, we can deal with that. But we will not be chipping away at LEOBR and giving out specific rights. Now, if the chair comes in here and says, the speaker says, you no longer are vice chair, show cause order for me? I mean, it doesn't work like it doesn't work like that. There are normal procedures that people have to go through, and that I'm not asking. I guess I'm asking myself a question, huh? But there are normal procedures that people have to go through that that make sure that the law is fair and that everybody is treated the same. And that was the problem we had with LEOBR, was that we were carving out special laws for certain people. So that's the first thing. Now tell me why this isn't carving out laws for a certain sector of people.
Yeah, so thank you for the question. So contrary, this isn't about wearing a tie, not wearing a tie. This is about people bringing forward issues that may be within, whether it's a whistleblower statute or the like. This is about a process that allows for these employees that aren't elected, that are, you know, they're not elected. So, you know, as bad as the shell game happens, it can happen here, right? But these are people that are hired, and they're also have the opportunity to work certain secondary employment, or they have the opportunity to work things outside of their normal course of duty. But some of these things get brought back into their employment because of their certification, whether it be for pointing out, you know, a policy issue that might be contrary to law, or contrary to how they want to be handling things in the public eye, or they're trying to make things better, and then as a result of that, the action is adversely taken against them. So this isn't chipping away at LEOBR. This isn't chipping away at the Police Accountability Act. This is actually creating and making it better, so that these people, these men and women that we hire as law enforcement officers, that they can't have, look, everyone is entitled, every person that law enforcement deal with in the course of their duties, they're entitled to a speedy trial. They have a right to a speedy trial, every one of them. You know who's not entitled to a right to a speedy trial when they get an aggrieved action taken to them by one of their police executives? Law enforcement. It can drag out. It can drag out way longer.
But doesn't it drag out the same for any other employee? It does. No. I mean, we just had someone ask a question about what do other employees do. You file a civil suit, you file a discrimination suit, you get a lawyer. I mean, that's what usually happens. I really don't want to argue about it, but I wish okay, so this was 2021, so it probably went in effect in 2022. So it's been 4 years. Mm-hmm. Tell me about what has happened to precipitate this bill.
We have people that are being affected by actions that are not followed.
How many?
Can give you 3 examples right off the top of his head.
3 people?
3 examples.
In 5 years?
3 different departments. That's just off the top of his head. The point is that these aren't under the purview of the Police Accountability Act. These are not.
But they could interfere. The process could interfere with the police accountability.
No, this would not.
It could.
No, this is separate. This is not disciplinary as far as.
I understand, but if you
this doesn't fall under the ACC.
If you have 2 proceedings going on at once, one has to take precedent. So if there was a disciplinary case going on at the same time, and you decide to file or someone decides to file a show cause, you can't have 2 processes going on at the same time. It would stall. One of them would stall. Yeah. One of them would have to stall in order for the others, because you've got the same evidence or similar evidence that are related to both.
But this doesn't fall within the trial board process. This is carved out.
I said if there was a disciplinary process going at the same time, that it could affect the disciplinary process.
But this is not a disciplinary process that has actions under the ACC. This is separate. This does not fall under the PAB, and it doesn't fall under the ACC. These are actions taken by an employer that don't have the same remedies available for an ACC action. They don't.
Okay.
Well, what the vice chair is saying, that if you have a disciplinary hearing going on, or disciplinary case going on, and you have a whistleblower case going on, She's saying that one of them is going to stall. She's not saying that this is disciplinary. She's saying that you have two cases simultaneously.
Are we talking about this for the same employee?
Yeah, I think that's where you were going, right? Okay.
Okay. Yeah, I don't have any other questions. Thank you.
Okay, thank you.
Members, do we have Delegate Simpson?
Yes, okay. All right, I'm gonna try to make this as quickly as possible, because I do think, you know, a concern that I have with your bill is also unintended consequences, because if you're directly going to the court, we've just heard several bills about, you know, folks are like, I don't want that if I'm now trying to go to Tawnytown and be a police officer and I just, Seat Pleasant, I just, sued them because they didn't let me have that secondary. Now I have a case that anybody can look up, and that's specific to, that's what I did, is sued my employer because they wouldn't let me have a second employment. I don't know if you've thought of that, but an unintended consequences is for every other employer, you now have a case sitting there. That's one. I am, just like when I met with all of you when you came into my office, said I was shocked, just like everyone else. Why are you immediately going to court? Like no one else would have that. State employees would go to the EEO, or they would internally, even the state police. So there's a process that they can go through if they're a whistleblower. There is a process that if they are, the personnel. And then if you are not like a state employee, or you're not like a county or a government employee with their own set of procedures, there is, if you're outside of that, you can go to the Attorney General. And then once again, you're not immediately having this document. I mean, we're all going to end up in the circuit court if they keep saying no. That's already the process usually when it comes to personnel procedures. Eventually, you are grieving to the extent of saying, well, I still don't agree. And then you end up at the circuit court. It just seems a little odd that you automatically want to end up there and that you would want that on that record. It does seem, I believe, where is your union in this? Because that's another, like you could go to the union, you could go to the civil rights. They do whistleblower. You can, now they have a longer period of time, but even with the courts, I mean, it's not going to go away. It's going to sit there, even if you won. I'm asking, did that ever come up, the fact that you were developing a court case for each and every one of these cases?
And these are if that were the case, I'm sure that they would be willing to stand by their action that they took and be able to explain it, because the problem is not all agencies have policies in place to resolve these matters because they are outside the scope of the ACC and the PAB. This is within the agency. So that's one. Secondly, if they're going to move between agencies, I mean, that's their risk. That's their, I don't know how that's relevant to this, honestly, because police go through a very thorough background check regardless. So it's going to be there. And it's also going to be a part of their jacket of their personnel file should they apply for employment elsewhere. I think there was one more question in there somewhere, but I don't.
No, that is typically that's required by law to be separate, actually. So no, it wouldn't be.
What's that?
Would be if you filed an EEO or you filed a complaint about your your performance or whatever. Those things are not.
You said a court case. You said a court case.
I did say a court case, but that's why I'm asking you, why are you going in this direction as opposed to having like a normal.
And then the other part to your question was, not all agencies have an FOP. They don't all have a union representative. They're protected by, if you will, or they fall under the purview of the Police Accountability Act, but not all of them have an agency rep that's going to be able to go and file suit. I mean, there's very small departments in this state.
I know, I am fully, as someone who has a different job, I'm fully aware of many very small
Very small little
jurisdictions that have
departments. And
little,
so,
just
and this,
three or
this would
just
just
one.
give harmony under the idea that if there was an adverse action, that the agency executive would have to show cause on why they would continue this pattern of adverse action without being able to justify. Because that's the reality of it. They can sit there and create a hardship on an employee over an extended period of time because they can. For an action that's not of a police-related disciplinary measure that falls under the ACC or the PAB.
Well, I had brought to the folks that were the sponsor, I said, did you really want to go directly to the court or develop something perhaps a little more
This is the bill.
stair-step?
This is the bill that's here before us today, Delegate, and this is the bill that was moved out of the Senate, and this, you know, with a lot of dialogue and back and forth, and actually making very good amendments to it. So I think that it's very detailed oriented, but it's carved out very specifically for an area that's not going to chip away at the MPAA, and it's not going to create any type of negative loopholes that are going to be detrimental to the MPAA.
Interesting.
Okay, so I just want to go to one section, one thing. I'm looking at the Chiefs and Sheriffs Association opposition testimony, which you may or may not have. But interesting enough, I was just understanding what page 3 does, which is the section E, the only section that's been added to the bill now. They're saying they'd be all right with the bill if you took out the section that says for which the denial is not eligible to be remedied by a trial board under section 3-106, which is interesting because that's the very part that seems to carve out things that would go to the trial board. So that part I'm a little confused. Yeah, but see, they're saying that they would go ahead and take it. They wouldn't oppose it if we took out that carve out, which
The carve out about the trial board?
Yeah, I find that interesting. So anyway, I just wanted to bring that up.
Yeah, I mean,
yeah, you don't have to.
that wouldn't even fall under this because it's
so
not
what
a
they're
trial board.
saying essentially is that it would read instead, a police officer was denied a right under this whistleblower section could go to circuit court for a show cause. That's essentially what they're saying. They would be able to support that as opposed to including the trial board in the, or not including the statement that excludes the trial board. There you go. Okay, we're gonna keep going. This was supposed to be be a fast one, Senator Muse, but we're almost there. Delegate McComas, please.
Senator Folden, I've been around here kind of long, not as long as the dinosaurs, but anyway, the question I have for you is, I remember quite a while ago that we learned about the fact that when they originally did the boards for the police and everything, it was done very deliberately and carefully. And I'm just wondering, now I think the whistleblower, that is very important that they be protected and they be able to not have to be pressurized. Do you think that if we didn't get into the trial board, but the whistleblower would be allowed this way of going, would that be helpful? That in other words, you don't take the whole pie. You take because I think whistleblowers are very important.
Yeah, but that's what the bill does. It creates that separate avenue.
Okay, but in other words, does it have other things than just the whistleblower though? The bill.
Everything in 3.110. That's what's covered. What's under 3.110.
Okay, all right.
And that's on the first page.
But I mean, is it clear enough so that folks can follow the procedure? Okay, I see nodding, so that's good.
It's very clear. I mean, it talks about disclosed information that evidence is mismanagement, a waste of government resources, danger to public health or safety, a violation of law or policy committed by another police officer, or lawfully exercised constitutional rights.
Okay.
I mean, it's pretty
Okay.
It's pretty tailored, pretty tightly about that.
Now, let me ask you this. What if a guy accuses somebody of, that they rat on the guy and the guy's innocent, then does he have any?
Well, and then that comes into the.
Any relief?
Well, that would come into the arena of, if that was an inaccurate statement being made, then that's truthfulness, that's integrity, so that would be a violation within, that could be accountable.
So for what your bill's about, or for the trial board?
That would be for the trial board.
Okay, all right. So there's a remedy?
Yeah.
Yeah, okay, thank you.
Thank you.
All righty. Delegate Woods?
Hoping that this is going to be a short response. 2 quick questions.
Yes, ma'am.
Senator, can you tell me what's the origin of the order to show cause, and where else does this take place?
What the order that?
What is the origin of the order to show cause, and where else do we see this take place?
I mean, it's pretty broad. Yeah, I don't know that. I mean, that would be pretty, I don't know. That's pretty broad.
They took that out of.
One moment, please.
Sure.
Mm-hmm.
Me too.
Directs the law enforcement agency to show cause while the right should not be.
The Senate struck that language.
Directs the law enforcement agency to show. Okay. All right.
Oh, sorry. Yeah, but it's at the end.
Yeah, yeah. Okay, we'll make this an after conversation. Thank you.
Did you want to ask your second question, or?
Thank you.
Does that take
No,
your-
because they're both related.
Okay.
Thank you.
All
Yep,
righty.
thank you, Delegate.
Okay. So, anyone have any other questions? All right, seeing none, that concludes this panel and our bill hearing for our sponsor-only bill hearing for Senate Bill 202.
So I'm going to close out my statement as I began. I guess I wasn't good to be back in Judiciary. Thank you, Madam Chair.
Thank you. All right, see you. Okay, Senator Muse, we are ready for you now. And then Senator Hester, I will call on you next. Senator Folden took up all your time. It's like.
I promise I won't be long, because you've heard these bills before. I'm looking around, oh, wow, I've seen a lot of you all in my committee. I am fighting for your bills like crazy.
Senator, you have 2 bills. If you want to start with, whichever one you want to start with is fine with me. These are sponsor only.
Okay, right. I will start with the 320.
Okay, and mind you, members, we passed out the cross file of this bill, of Senate Bill 320.
Okay. Second. Oh, I'm not on this committee. I'm sorry. Good afternoon again, Madam Chair Bartlett and Vice Chair Davis and members of the committee. For the record, I'm Senator C. Anthony Muse here to present Bill 320 as amended by the Senate. The bill is a technical fix to Maryland's expungement statute. It ensures that cases resolved with a no-finding disposition are treated consistently under the underlying charge. Simply put, if the charge itself is eligible for expungement, then a no-finding outcome should also be eligible. This is a fairness. There is a fairness about this, consistency and clarity in the law. Currently, individuals can be denied expungement solely because of how a case was handled procedurally, not because of the outcome. That creates confusion. During the interim, we worked closely with committee counsel, the Maryland Judiciary. Together, we crafted language that the courts can implement, making no-finding dispositions eligible for expungement. However, during the drafting process, language was introduced that deviated from that agreement and created implementation concerns. The Senate amendment simply restore the agreed upon language. ensure that the bill can be properly implemented by the courts, maintains the original intended scope of the legislation. And I want to thank this committee for passing the House file offered by my friend Delegate Taylor. It simply ensures consistent application of existing laws. It is a fix. It is a practical fix supported by stakeholders and ready for implementation. And for these reasons, I ask for a favorable report. Shortest testimony I've heard.
Okay, members, do we have any questions? Yeah. Delegate Phillips.
Trying to multitask. I'm sorry, Senator. So did I hear, may have missed it, it is in exactly the same position as Senator
No, it actually has been amended.
Okay.
Yeah, it has been amended. And the Senator went over the amendments a little bit. What I don't understand, though, and I'm going to hijack your time just for a second,
No,
okay?
no problem. You're asking me.
What I don't understand is the part about if the person is convicted of a new crime during the applicable time period set forth in Section C. I thought we weren't using this, so we're not, I thought we weren't using this terminology anymore.
Is that the terminology that the
So I thought the terminology was something about, if this is the, no finding, case terminated without finding. I thought that was the terminology. I didn't think we used it anymore. So my question is, would there be, it seems like because, okay, someone got the no finding or terminated without finding.
Right.
This language is confusing me, and I'm not looking at the entire reprint, so that might be my reason. But I'm seeing that if the person is convicted of a new crime during a particular time frame, then the original, I'm sorry?
The original, that's not, that's not.
Hold on 1 second. Okay, I'm looking at Amendment 2.
You want to see it? This is the reprint.
Yeah, okay, hold on, I've got it. All right, hold on just 1 second, Senator. I apologize for that. Okay, so it was taken out.
Right. Yes, and they made the bottom line that all that we agreed on with the courts and all else would then change it and make it applicable that way.
Okay, so the amendment that I'm looking at is saying to insert it, so this is kind of interesting. All right. Okay, no worries. It is clearly out of the bill. Is it put in somewhere else? Is that why it was deleted? Nope. All right. Yeah, hold on 1 second, please. Okay, Delegate Taylor.
The amendment that's included, that was added in the Senate, who submitted that amendment?
I think the chairman.
This is the chair's amendment.
Yes, the chair's amendment. Right.
JPR's amendment? Okay. And with this amendment, does this have something to do with the unit rule? Make any clarity?
No, but I second what you said, yes.
Okay.
That's correct.
Okay.
Well, okay. All righty, members, do we have any other questions? All right, seeing none, that concludes our bill hearing for Senate Bill 320. Now we're going to move on to our next bill with Senator Muse, Senate Bill 464.
Thank you very much. This, for the record, I'm C. Anthony Muse to present Senate Bill 464 as amended by the Senate. Senate Bill 464 establishes a commission to just examine Maryland's expungement laws. I was grateful to have been the one to put this, to do the bill and then to put the bill and amend it into the Second Chance Act to make that altogether one bill, specifically Title 10, Subtitle 1 of the Criminal Procedure Article. It establishes a commission to examine Maryland's expungement law. The goal is straightforward: to streamline and ensure equity and consistency in how expungement laws are applied across the state. As the committee is aware, there have been ongoing concerns about complexity and inconsistency in our expungement framework. This commission provides a structured, balanced approach to evaluate the law, identify gaps, and recommend improvements grounded in data and stakeholder input. Since the House has already heard the cross-file, I'll briefly highlight the Senate amendments. There is an adjustment of the timeline. The effective date has been moved to June 1st, 2027. This ensures the commission's work is not conducted during campaign season and allows for focused, uninterrupted engagement. The amendments strengthen the commission by adding key stakeholders to ensure balance and credibility, including law enforcement representation through police chiefs and sheriffs, Maryland Network Against Domestic Violence and Maryland Crime Victims Resource Center. This ensures the victims' voices, public safety perspectives, and community interests are all represented at the table. Expungement affects employment opportunities, as you know, housing access, long-term economic stability. At the same time, it's got to be balanced with public safety, victim rights, and transparency, and I see that is what I believe we reach. The commission allows us to take comprehensive and responsible approach to that battle. Senate Bill 464, as amended, creates a thoughtful, inclusive process to review and to improve Maryland's expungement laws. Senate Bill 464, again, to make this balanced, and I think it is. And for that reason, I ask for a favorable report, as you all did in my committee.
Members, do we have any questions? All right, seeing none. Thank you very much,
Thank
Senator.
you very much, my
That
delegate,
concludes
best
our
delegate.
bill hearing for Senate Bill 464. Okay, we're going to move now to our last bill hearing, and thank you, Bridget O'Toole, from Chief of Staff from Senator Hester's office. We're going to hear Senate Bill 8. Thank you very much for your patience. I understand you've been here all day, and I did not intend to overlook you.
It's no problem. I think Senator Hester was here for a second again, but then had to pop out. So she's really sorry that she missed this. So yeah, I'll just jump in. Chair Bartlett, Vice Chair Davis, and members of the Judiciary Committee, for the record, I'm Bridget O'Toole, Chief of Staff to Senator Hester, here on her behalf today. Thank you for your consideration of Senate Bill 8, Criminal Law, Identity Fraud, Artificial Intelligence, and Deepfake Representations. This legislation is essential to strengthening Maryland's ability to combat identity fraud by addressing the evolving threats posed by AI and deepfake technology. For context, you did hear HB 184, which is the House version of this bill sponsored by Delegate Pasteur in this committee. Senate Bill 8 passed unanimously out of the Senate with one amendment, so I'll be brief and just kind of touch on what that amendment does. Briefly, just to remind you guys what the bill does, it criminalizes AI deception, creates a path to justice and provides restitution, expands and modernizes definitions in the identity fraud statute, strengthens penalties, and enhances and expands enforcement. So as I noted, this bill passed the Senate with one committee amendment that both addresses concerns raised by the Motion Picture Association and clarifies the bill's intent. Specifically, the amendment refines the language on page 8 of the bill to ensure the prohibition applies only where there is knowing, willful, and fraudulent intent to cause harm through impersonation, false depiction, or to claim to represent a person using AI or deepfake technology. Importantly, the term mislead, which raised some concerns about overbreadth, was removed, and that should appease MPA's concerns. One thing that Senator Hester asked me to emphasize is that she thinks it's really critical that we pass this bill this year. Concerns about the use of AI, especially in the elections context, are really prevalent right now. And when we look at how it can be used to mislead voters about candidates, this bill will address that. So let's say a bad actor creates a convincing deepfake of Senator Hester using hate speech and disseminates it online to manipulate voters. Without this bill, there's really little to no legal recourse to stop that harm or hold anyone accountable. So for those reasons, I would request a favorable report on behalf of Senator Hester.
Thank you. And there's a new scam going on, and that is where someone will use a family member's voice.
Yeah.
Yeah. So would that, and I don't want to go into details in case scammers are listening, but would that be
Yes.
covered on this bill?
It would.
Okay. All right, great. Members, do we have any other questions? All right, you did a great job. Thank you so much.
Yeah, of course.
All right, that concludes our bill hearing for Senate Bill 8. That concludes all our bill hearings for the day. We are adjourned.